I definitely want to. I do get to. And the last time I was here in January. Oh, yeah. Yeah, that's like a one. Maybe a month. Yeah. Yeah, there's too many
Brian,
why are you guys makes you wonder if they'll never breathe.
14A District Court for County of Washington, State of Michigan, now in session. All those having business before the court draw near, the Honorable Judge Dave Cedric.
You may be seated.
Good morning, Your Honor. Ashley Lonnie Feltus for the people. Your Honor, at this time, the people will waive any conflict between this court and the Office of the Public Defender. The people do not believe that any conflict exists and make the waiver for the avoidance spelled out.
Thank you. Mr. Brown.
Thank you, Your Honor. Good morning, Lauren Brown, Deputy Chief Public Defender. We likewise do not believe that any conflict exists in this honorable court hearing these matters. If a conflict were to arise, we would waive such conflict so that this honorable court could hear these matters.
Mr. Brown, I was remiss last Thursday in not wishing you a happy birthday.
Oh, thank
that
you.
You had another year.
I'm almost as old as you now, Judge.
What'd you say?
I'm almost as old as you now.
You know, okay, and I wasn't going to say this, but I'm going to say this now. I actually came across an old picture of you and you had hair. I'll show it to you. Thank you, Ms. Brown. The court for its part also does not believe there's a conflict either under Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. The court does call the case of the people of the state of Michigan versus Kurt Kwiatkowski. Should be.
Defender Payne with behalf of Mr. Kwiatkowski.
Is that the Forensic Center?
Yes, sir.
Right.
Ready.
Sir, if you could state your name, please.
Kurt James Kwiatkowski.
Thank you.
Thank you. Today is the date and time set for a competency review hearing. Does the court have any updated?
I have a report dated August 25th. That's the last report I have. All right. Any other additional evidence?
We have no additional information to present to the court.
Nor do the people. We would stipulate to that report and ask the court make the entry and the finding the defendant is competent to stand trial.
Court, upon reviewing the report, would find that the defendant is competent to stand trial. Specifically, the court would indicate that the defendant can understand the nature and object of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent.
Thank you, Your Honor. At this time, I believe an order has already been presented to the court.
Pardon?
An order should already be filed.
I did not see an order, sir.
All right, we will have order prepared and presented to the court. Now we are respectfully requesting that a probable cause conference date be set.
You want a couple weeks out? Well, it'll have to be a couple weeks out if he's there. Is he going to be released from the Forensic Center?
I would think so.
Yes. I expect that.
So if he's going to be released, today is the 18th. I don't have the 2nd, so why don't I set it for October 9th if that is not a problem for.
Thank you, Your Honor.
Probable cause conference will be set for October 9th, 2025, 9 a.m.
Thank you, Your Honor.
Bond will continue. All right, thank you. And I'll await that order and sign.
Thank you, Your Honor.
Court does call the case of the people versus Christopher Atkins.
Jennifer Douglas with people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Atkins. Will you state your name for the record?
Christopher Roy Atkins.
Thank you,
you.
sir.
Your Honor, we're asking for an adjournment. Mr. Atkins is hoping to get into a treatment court in Livingston County. The next court date is October 3rd. For that, so we'd ask for an adjournment after that date.
After October 3rd.
Please.
All right. Set it then for October 9th. Without objection, 2025, 9 a.m. Bond will continue.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you, sir. Court does call the case of the People versus Jay Dingman.
Morning, on behalf of the state permission to practice under Michigan court rule.
I can't hear you. Tell Cook to move. No, that's fine. You took the second seat because Valdez took the first one, but go ahead. Go ahead, Ms. Lowe.
Clearly requesting permission to practice pursuant to Michigan court rule 8.120 under the supervision of Assistant Prosecuting Attorney Jennifer Docket.
Permission to practice is granted.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Dingman. Mr. Dingman, will you state your name for the record?
Jay Dingman.
Thank you.
All right. And I have before me a plea form. Is that what we're doing?
Correct.
The plea form indicates that the defendant would be pleading no contest to an added count 2 of disturbing the peace. The 90-day offense upon a successful plea to that charge, count 1 would be dismissed. There is also the recommendation that he will comply with the mental health treatment plan in the 22nd Circuit Probation Court. And then you list the case number. That's the court's full understanding of the agreement.
That's correct.
Yes, Your Honor.
All right. Mr. Dingman, would you raise your right hand to be sworn? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
I do.
State your name again for the record, please, sir.
Jay Dingman.
All right, Mr. Dingman, your court's understanding is you're going to plead no contest to the charge of disturbing the peace. That is a misdemeanor punishable by up to 90 days in jail, a $500 fine plus court costs. Do you understand that?
Yes, I do.
All right. Do you understand what a no contest plea is?
Yes, I do.
All right. 2 things about it I have to make sure that you understand. First of all, it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, I do.
Second thing is that for purposes of sentencing, the court's going to treat you the same as though you had pled guilty to the charge. You understand that, sir?
Yes, I understand.
Basis for the no contest plea.
A lack of recall.
All right. To that charge, how do you plead, sir?
I pleaded guilty.
Mr. Dingman, no contest is what we discussed. You'd have to state no contest if that's what you wish to do today.
No contest, please.
All right.
Thank you.
You understand that by pleading no contest, you will not have a trial of any kind.
Yes, I understand.
You signed or went through with your attorney an advice of rights form.
Yes.
Do you have any question regarding any of those rights?
No.
The rights under paragraph 5 are your trial rights. You understand that you're giving up those rights as well as all the rights that are on that form.
Yes, I do understand.
You understand you're giving up your right to appeal of right.
Yes, I understand.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
and of your own free will.
Yes, I am.
All right. The court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 259660. Any objection to the court having reviewed that report?
No objection.
No.
Upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Mr. Dingman, I'd have to advise you that if between the time of my acceptance of your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled, the court would no longer be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes, I understand.
You understand also you would not be entitled to withdraw your plea.
Okay, I understand.
Understand that? Okay. Counsel, are there any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And has the court complied with the court ruling? Would it be proper to accept this defendant's plea?
Defense is satisfied.
People are satisfied.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
October 8th at 9 a.m.
October 8th, 2025, 9 a.m. before me.
Your Honor, if I may address bond briefly on my client's behalf.
No, I was talking about that.
Thank you.
What happened this early, but go ahead.
Your Honor, I'm asking the court to consider a release on a personal bond. I did have a chance to meet with Mr. Dingman. This is the only matter holding him. He does have a cash bond on a 14B case that my understanding is to convert to a PR. If this case is converted to a PR, it's $1,000, 10% right now. Mr. Dingman has been complying with the probate order. He's been receiving his medication. This is a 90-day misdemeanor he pled to, and he currently has 55 days credit for time served. Based on that, I would ask for consideration for, or if not, maybe after he completes his PSI in custody.
Response.
Your Honor, we would leave it up to the court's discretion. He is currently undergoing treatment.
All right. What I will do is I'll grant your request and deny your request in part. His bond will become a PR after he's in probation.
Understood.
All right.
Thank you. Thank you, Judge.
Thank you. In part. Court does call the case of the People versus Dalton Hall.
We're ready then.
Good morning, Your Honor. Laura Willenberg on behalf of the people.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Hall, who approaches from my right. Go ahead and state your name for the record.
My name is Dalton Hall.
Thank you.
Your Honor, today is the date and time set for the probable cause conference. We just received some further information in this case. We would ask for a week adjournment so that we can process that and talk about options for my client. He needs to be informed of certain developments in this case.
All right. Just procedurally, as to he's not been arraigned on counts 5 and 6.
Oh.
Wait formal reading of those counts. And
Yes, Your Honor.
he stands mute.
Yes, Your Honor.
Defendant having waived formal reading, standing mute as to those counts. Court will enter a not guilty plea.
Thank you, Your Honor.
Any objection to the 1 week adjournment?
No, Your Honor. I will also at this time move to dismiss counts 1 and 2 as they were corrected by adding those amended counts.
Gotcha. Okay. So I will dismiss counts 1 and 2 in this case. No objection, I'm presuming this.
No objection. Thank you.
You want a 1 week adjournment?
Yes, please.
So do you feel at your age you don't have to give me a green sheet? No, that's okay. It's all right. I won't. I don't need an answer to that. I'll wait.
Let me
All right.
Okay. I got one for you. I'll get you one.
Probable cause conference in this case will be adjourned to the 25th.
All right. Thank you very much, Your Honor.
Continue. Court calls the case People versus Timothy Flood.
Ready, Your Honor. Good morning, Your Honor. Joe Simon on behalf of Mr. Flood, station agent.
Timothy Flood.
And at Mr. Simon's age,
Ouch.
you got me this year.
Mr. Vincent and Mr. Goldstein and I were having that discussion, Your Honor, and it is official that I cannot deny that age anymore. So
Okay.
I think I have to concede.
Very good.
In this case, Your Honor, I made a proposed resolution to Ms. Willenbring the other day that she's going to consider. We're asking the court to adjourn well, there's no commitments. I'm sure she's going to add that in a minute, but she's going to at least consider what I've offered.
All right.
That's right.
I can go to the 30th or the 9th.
The 9th, I'm traveling, Your Honor, and I don't know if let me just check the 30th real quick. I can do the 30th. Can you, thank you.
Probable cause conference will be adjourned to September 30th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
All right, Tim, you can get out of here. All right, see you.
Court does call the case of the people versus Winona Harvey.
We're ready. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Ms. Harvey, he approaches.
Can you state your name, ma'am?
I don't know my name.
You don't know your name?
No.
Okay.
I can't use my first last name and I was born no middle name.
Okay. All right.
My family, nothing.
And what are we doing?
Your Honor, this matter is set for a competency review. We do not have an updated report in this matter. Does the court have an updated report?
I do not. I have not received a report.
And I believe it might be appropriate for us to wait to get an updated report.
You know my name?
Yes.
Winona Harvey.
Got it.
I'm appearing with and on behalf of Ms. Winona Harvey.
All right. Has anybody contacted the Forensic Center to see when a report might be forthcoming?
We've gotten no communication on that.
Ms. Lowe?
Yes, Ms. Akinruli had contacted them prior, and initially they had said that the report would have been done by today, which is why we haven't said.
Why we had it set for today, that's what I thought.
Still waiting.
All right, what I'll do is this, I'll adjourn the competency hearing until October 30th. We will move that date up if the report comes in pursuant to the statute. So October 30th, 2025, 9 a.m.
Thank you very much. Your Honor.
All right.
Okay.
Bond continued.
Thank you.
Let's call the case of People versus Jordan McKinney.
He was here earlier. Look out in the hallway. David I. Goldstein, appearing on behalf of the defendant.
It'd take a while.
State your name, please.
Jordan McKinney.
Your Honor, I believe that the discovery has been provided. We're asking the matter be set for preliminary examination.
For the record, I was prepared to make a very reasonable offer. It doesn't sound like we are in that stage, so we'll move on.
Well, I will consider that between now and the date of the exam. Not considering the
That would
offer.
make me very good.
Okay.
As they're done. Discovering they haven't been completed. Would the people have their witnesses? We're on the 30th.
Yes.
Sorry, what date, Your Honor? Sorry.
People have their witnesses available September 30th.
I believe so, Your Honor.
Preliminary examination in person will be set September 30th, 2025 at 9 a.m. before Judge Watt. Bond will continue. That's called the case of People versus Justin Scott.
Judge Phelps for the people.
Right, Judge. Torshio Feaster, Assistant Public Defender, on behalf of Mr. Scott, who's approaching the podium. Mr. Scott, please state your name for the record.
Justin Scott.
Thank you, Judge. I spoke to my client. I reached out to the people on this matter. We are still negotiating. I'd ask for a 2-week adjournment, please.
I have 1 and 3.
Oh.
Well, I have the 30th.
Let's go the 3.
Pardon?
Let's do the 3, please, Judge.
The 9th.
Yes, Judge, because I'm going to ask you now for a release to treatment.
Probable cause conference will be adjourned October 9th, 2025, 9 a.m. Bond will continue. If you send over the release treatment order, I will.
Thank you, Judge.
All right. Thank you. Thank you. Court calls the case of the People versus Christopher Coffey. Miss Wiley, approach, please.
Good morning, Your Honor. Jay Grant Miller, P58658, on behalf of Mr. Coffey, who I have not been able to locate.
Okay.
Oh.
I talked to. Well, good morning. Good morning. Who's the prosecutor on this?
It's Raymond for people.
God, I hate to do this so early. Did you pull those?
I can for you.
I don't have them. Can I see counsel in back just momentarily? Court is standing brief recess, everybody.
Good night. Good night.
Thank you very much.
No, it's right.
I don't understand what happened. What happened?
Williams.
Ashley's Office for the People.
Assistant Public Defender Chelsea Vergils with and on behalf of Anthony Williams, who is in custody.
I have this as an AG case.
I was looking at Jeffrey Williams, Your Honor. I apologize.
All right.
Anthony Williams.
All right. State your appearance, please.
Jesse Green, Special Assistant Attorney General, here on behalf of the people, Your Honor.
He's in custody.
Yes, Your Honor. We're planning on waiving the preliminary exam. I actually didn't sign the form.
No objection, Your Honor.
Anthony Williams. All right. He's waiving preliminary examination.
Yes, Your Honor.
Sir, is that a correct statement? Yes, sir. You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it? Yes, sir. You understand you'll not have that hearing. You'll proceed to circuit court for further resolution? Yes, sir. People also do waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over on a single count.
We acknowledge receipt of the information, waive its formal reading, and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
September 30th at 1:30 with Judge Conklin.
September 30th, 2025, 1:30 before Judge Conklin. Bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, sir. Court does call the case of the people versus Rayshawn Dawson.
Morning, Hunter Sam Bernstein with and on behalf of Mr. Dawson. Mr. Dawson, could you please state your name to the court?
Rayshawn Dawson. Thank you.
Your Honor, we're asking for an adjournment, please, to review discovery.
Without objection, probable cause conference will be adjourned October 9th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court calls the case People versus Douglas Brown.
Good morning, Your Honor. Michael Vincent on behalf of Douglas Brown. Mr. Brown, state your name.
Douglas Steele Brown, Your Honor. Excuse me. Good morning.
Good morning. Your Honor, this is a day probable cause conference, and I'm going to request an adjournment. We still have discovery to get.
Well, where's your? Okay. Yeah, exactly. I lost you there, and I said I'm not asking Vincent. Well, October 9th work. All right.
Thank you, Your Honor.
Our cause conference will be adjourned October 9th, 2025, 9 a.m. Bond will continue. Thank you. Court calls the case People versus Terrence Ginyard.
Jesse Green, Special Assistant Attorney General, here on behalf of the people, Your Honor.
Thank you.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Ginyard. Mr. Ginyard, can you please state your name for the record?
Terrence Ginyard. Go ahead.
And Your Honor, I am asking for an adjournment today. I have reached out to AAG Williams on this matter. I wasn't aware that a different AG might be covering today's case. So I am just seeking an offer from them. I did just get good contact information from my client as well, so I'm just seeking a 2 to 3 week adjournment.
Without objection, I'll adjourn this to October 9th, 2025, 9 a.m.
Your Honor? May I ask that we schedule for something after the 10th? We're concerned about a government shutdown, which would mean we wouldn't be able to appear for hearings.
Hold it. That state government shutdown?
Yes, Your Honor.
Hold on a second.
Unfortunately.
But I'm a county.
I know you are, Your Honor, but
no, I was just looking for time off. I'm just.
They wouldn't.
So you need something after the 10th, you believe?
Yes, Your Honor. Thank you.
So, well, he's out of custody. I'll tell you what, because I don't know what that means. I maybe have to read up on that. Let me go to October 23rd.
23rd. Thank you, Your Honor.
Yeah, all right. October 23rd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Oh, who else? Your county?
Location, date, time. You need to be here next, okay? And I will reach out with your new number as soon as I know.
All right. Thank you.
All right, take care.
Yes, go ahead. Court calls the case, People versus Quentin Coleman Ebersol.
Your Honor, good morning. Joe Simon on behalf of Mr. Ebersol. State your name, please.
Quentin Coleman Ebersol. All right, I have before me a plea form. That's what we're doing?
Yes, Your Honor.
Indicating that he's going to plead no contest to 3 charges. First charge is count 3, larceny 200 to 1,000. That's a misdemeanor punishable by up to 1 year incarceration. Also, intentionally dissemination, of sexually explicit visual material, 93-day misdemeanor, and count 5 of domestic violence, also a 93-day misdemeanor. Upon his successful plea to those 3 charges, counts 1 and 2 would be dismissed. There is an agreement that sentencing to be determined by probation, and that's the court's full understanding of the agreement. Is that correct?
That's correct.
Your Honor, that my client's ready to enter those pleas. Because he was in custody, I read to him all of the forms and he authorized me to sign on his behalf, and I reviewed them again with him this morning.
All right, very good. May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and the truth so help you God?
Yes, I do.
State your name.
Speak up a little louder.
Quentin Coleman Ebersol. All right. Sir, it is this court's understanding that you are going to be pleading no contest to 3 charges. Is that correct?
Yes, Your Honor.
All right. The first charge is count 3 of larceny 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. The fine could be increased at 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes, Your Honor.
Also, then count 4, which is the dissemination of sexually explicit visual material. That is a misdemeanor punishable by up to 93 days in jail, a $500 fine plus court cost. Do you understand that?
Yes, Your Honor.
And also then count 5, the charge of domestic violence. That's a misdemeanor punishable also by 93 days in jail, $500 fine plus court cost. Do you understand that?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, Your Honor.
All right. 2 things about it. I have to make sure that you understand it. First means that you're not further desirous or wanting to contest these 3 charges. You understand that?
Yes, Your Honor.
The second thing is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge. And you would be sentenced by Judge Freshour in the 14A4 District Court.
Yes, Your Honor.
All right. Basis for the no contest plea.
Potential civil liability, Your Honor.
All right. Sir, to the charge of larceny 200 to 1,000, how do you plead?
No contest.
To the charge of intentional dissemination of sexually explicit material, how do you plead?
No contest.
To the charge of domestic violence, how do you plead?
No contest.
And you understand that by pleading no contest, you will not have a trial of any kind?
Yes, Your Honor.
All right. You went through an advice of rights form and had your counsel sign that on your behalf. Is that correct?
Yes, Your Honor.
Do you have any questions regarding any of the rights on that form? No, Your Honor. There's a copy on the podium. Please look at paragraph 5. You understand that because you're not having a trial, you're giving up those rights as well as all the rights that are contained on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal outright?
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
The court has been provided and has reviewed Michigan Department of State Police report for their case number 5269-25. Any objection to the court having reviewed that report?
No objection from the people, Your Honor.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the guilt of the defendant with reference to these three charges. Sir, I do have to advise you that if you commit misconduct as defined by the Michigan court rules between the time of the acceptance of my plea and the time of sentencing, that you would not be entitled to withdraw your plea, and the court would not be bound by any sentence recommendation. You understand that, sir?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or inducements that have led to this plea?
People are not, Your Honor.
No, Your Honor.
All right. And have I complied with the court rule, and would it be proper to accept this defendant's plea?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's pleas of no contest. 2 counts 3, 4, and 5. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A4 probation. Sentencing in this matter will be
September 25th at 10:30 a.m.
September 25th, 2025, 10 a.m. before Judge Rushhour.
Your Honor, may I address bond? And with that hurried date, I'm telling my client, I didn't mean to take a minute to talk one thing. About just over 3 weeks ago, Your Honor, my client turned himself in on the court, revoked his bond. He had a $25,000, 10% bond originally. He admitted violating his bond by placing his call to his former spouse, or estranged spouse. And she contacted the authorities, and obviously that's how he's in. I'm asking the court to consider reinstating that bond. The amount of time he served is pretty substantial, but he knows he earned it. He wants to get back to work. And he was on a GPS tether before, and he certainly would wait to be tethered again if released.
Respond.
I believe it's a good course discretion. I will say people are very concerned about the behavior of this defendant, not only as the basis for the offense itself, but then violating it after the offense occurred and after he was specifically told what the conditions were. This is a situation where we have no, I think it's best left up to the PSIR. We would be more comfortable for staying in custody until the report has been done. And then, of course, they can make that determination and recommendation to the court. But at this stage, there are too many concerns, and they're adding up to be an unsafe situation for this victim.
I'm going to deny your request to change his bond once certainly the pre-sentence investigation is done, and you got a relatively quick sentencing date, certainly Judge Rushhour can make that decision. At this time, but motion for bond reduction is denied.
And then, Father, Your Honor, the court we have a change in address. Was that made already, or should we approach it?
Change in address of.
For the no contact.
That should be communicated directly to community corrections. Well, actually, we're going to have the no contact. If that can be provided in writing, we'll make sure that the file is updated. Thank you. Court does call the case People versus Imbe. Is it Indicate? Imbe.
Good morning, Your Honor. Assistant Public Defender Davi Lebo for Mr. DA.
Yep.
Jesse Green, Special Assistant Attorney General, on behalf of the people, Your Honor.
All right. He's waiving preliminary examination.
Yes, sir. He has executed waiver form, which I provided to the court.
Sir, is that correct? You're waiving preliminary examination?
Correct.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Right.
You understand that?
Yes.
You understand you will not have that hearing and that you'll proceed to circuit court for further resolution?
Yes.
People also waive their rights?
Yes, Your Honor.
And Your Honor, I do just want to put on the record that we're waiving with an agreement of an offer available with a delayed sentence.
That's correct, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on both counts.
Thank you, Your Honor. We acknowledge receipt of the information and waive formal reading. Enter plea of mute at this time.
Defendant having waived formal reading, standing mute, the court will enter a not guilty plea. Pretrial will be set for
November 6th at 1:30 with Judge Slay.
November 6, 2025, 1:30, Judge Slay.
Thank you, Your Honor.
Bond continued. Thank you.
Thank you, Your Honor. Have a great day.
You do the same, sir. Court does call the case of the people versus Dwayne Stevenson.
Good morning, Your Honor.
David I. Goldstein, appearing on behalf of the defendant.
Your name, sir?
Dwayne Stevenson.
Thank you.
Your Honor, I believe I have all of the preliminary, discovery in this matter. We ask the matter be set for a preliminary examination.
People have their witnesses available the 30th. All right. Preliminary examination. We set September 30th, 2025 at 12 noon. That's before me.
I'm sorry, did you say 12 noon, Your Honor?
Yes, sir. Bond will continue. Thank you. Court does call the case of the people versus Abdel Motion Osman. People versus.
And good morning, Your Honor. Brandon Bird on behalf of Abdel Mosen Osman.
And now she felt this for people in both cases.
Brown, case 25 F2 1031.
Your name, sir? Osman. All right. What are we doing?
Preliminary examination. Set preliminary examination and.
Is discovery complete?
Yes, Your Honor.
Mr. Bird, what do you wish to do?
Please, to set the preliminary examination, Your Honor.
Discovery is complete on your case?
As far as I know, Your Honor.
People have their witnesses available on the 30th?
Could we possibly go one more week?
Any objection from either side on that?
No, Your Honor.
No, Your Honor, that would be the 6th.
That, I think it would be the 7th. Will that work?
It'll work, Your Honor. Thank you.
Preliminary examination in both these matters will be in person October 7th, 2025, 9 a.m. before Judge Freshour.
Thank you.
Thank you.
Fine, thank you. Bond will continue. Thank you. Court does call the case People versus Manuel Hunt. That one I see.
Yeah, no, I got it.
Mr. Bird, you want to state your appearance?
Sorry, Your Honor. Yes, Your Honor. Good morning again. Brandon Bird on behalf of Emmanuel Hunt. Mr. Hunt, can you please state your full name for the record?
Manuel Julius Hunt.
All right, what are we doing in this case?
Respectfully, Your Honor, I would like to ask for adjournment in this matter just to get all the discovery. Actually, I just got all the discovery yesterday, but we have a chance to go over it and go over with my client.
All right.
Your Honor, no objection to the adjournment. If there's any discovery that's outstanding, feel free to contact our office and I'll make sure you get everything.
All right.
There is also another matter, Your Honor. Unfortunately.
Yes. I have 1 in 3 weeks, counsel. Which would you? Well, I have the 30th. I can set it for that date. Will that work for you?
The 30th will work. The 30th will work, Your Honor.
All right.
Thank you.
Probable cause conference will then be adjourned. This is a Tuesday to September 30th, 2025, 9 a.m. Yes.
Your Honor,
Thank you, Your Honor.
Hang on. Go ahead.
Your Honor, I received information that this defendant has made, as of when we last checked, 19 calls to the victim. I'm sorry, since being arraigned, 19 calls at her listed phone number from his kin as well as other inmates' kin. And the communication is quite varied. There are a lot of calls. There are several concerning statements, though, regarding getting on her about why she's not getting out, talking about that this needs to go away, and so on and so forth. And I'll make sure I share all of that with defense counsel. However, at this point, we would ask that his phone privileges be revoked, and if he wishes to have a hearing, we need a bond violation hearing.
Your Honor, we could definitely address the bond hearing on September 30th, but I haven't received any of these phone calls or any of this information to be able to have a valid argument against the prosecution at this point. So I respectfully ask to keep his bond the same until I have the evidence in front of me and I'm able to be on equal ground.
If you wish to have a hearing, certainly the court will grant you that, but at this time, based upon the representation, I'm going to revoke the defendant's phone privileges. His bond and all other aspects will continue, and then we'll see you on the 30th. Thank you.
Thank you, Your Honor.
The court does call the case of the people versus Gabriel Shawaka.
Good morning, Your Honor. Tina Sachs on behalf of Mr. Shawaka.
Your name, sir?
Gabriel Shawaka.
Thank you. What are we doing?
Your Honor, I'm asking for a preliminary exam date, please.
All discoveries complete?
To my knowledge, it is.
People have their witnesses available on the 30th? Preliminary examination in person will be set September 30th, 2025, 9 a.m. That is before Judge Wash. Bond will continue. Thank you.
Thank you. Thank you, Your Honor.
Court does call the cases of the people versus Annie Oglesby.
But the next one, I'll be first. Okay. I'm waiting to see the picture from yours. I think I know somebody that's on this. Yeah, so I'm gonna try and call them up and see what's going on with that. I say, Shamar, no, Shamar, maybe Peter. I say somebody. Yeah.
Okay. I don't have an order on the 15th District Court case. I do have obviously one on the other case. So.
Okay. All right then. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Ms. Oglesby.
Hi.
Can you state your name?
And Annie Oglesby.
All right. Thank you. All right. I have all counsel here for the record. All right. What are we doing?
So, Your Honor, today is the date and time set for a probable cause conference. I do believe that our office has discovered a conflict in our representation, and we will be moving to withdrawal. So we may need to have an adjournment of this matter for that case.
All right. Saxon, on the one that you are on, what do you wish to do in that case?
Your Honor, we're asking that to be set for a preliminary exam.
All discovery is complete in that case.
The judges.
Yeah, I believe it is, Your Honor. Yes, I do believe it is, Your Honor. I have all video.
People have their witnesses available on the 30th.
I'll try, Your Honor. Thank you.
Preliminary examination, that is in case 1022. Preliminary examination will be set in person for September 30th, 2025 at 12 noon. That's before me. Bond on that case will continue On the other case,
I know, what is my client's bond set at in the?
Pardon?
What is my client's or current client's bond set at in the 5753 case?
and it's a 1,000 cash or surety in that case. In the case before you, or that's your office is still on. In the other matter, I don't have an idea. Oh, in the case, because it looks like because of a bond violation, her bond is denied on.
Okay.
Your Honor, I'd like to make a bond motion in regards to that.
Hang on. In your case, Mr. Brown, I'll adjourn the probable cause. I'll just go 1 week out to 25th.
Thank you.
September 25th, 2025. 9 a.m. Well, actually, why don't I just go ahead? I'll just do it the 25th. And I'm presuming you're going to want to change the bond if there's a change in the other's bond. Go ahead, Ms. Saxon.
Your Honor, we understand the bond was revoked because Ms. Oglesby failed to test. She has arranged for to stay in Ypsilanti and be able to test. She'll be closer than she was living before. So I'm asking for a nominal bond to be set so she can go back to work, get reunited with her children, but also show that she is able to comply with the testing this time.
And for the record, Your Honor, my client has the same issues in this particular case. She would make a likewise request for a nominal bond.
But she is, was she already in, well, but she didn't do anything in regard to the testing. She just didn't do not a thing.
When she got released, she went back to Jackson. She did not have transportation, or more importantly, she didn't have the money to pay. She has now made provision so that she can stay with her in-laws in Ypsilanti. Therefore, it would be easier.
I gave her 2 times to get this done, it looks like.
The first time, Your Honor,
I was incarcerated.
Go ahead.
The first time, Your Honor, she was incarcerated in another county, and there was just a miscommunication. They did not know she was there, so she could not comply the first time. Because she
Right.
was
So when she came down, I said, then you need to go to testing, and she didn't do it.
I think that was a transportation issue.
Yes.
She did say that she would call and was unsuccessful and they would get anything done that way.
Motion for bond reduction is denied. I'll reconsider it at the time of her exam, but at this point, I'm going to deny the motion. In both cases, the bond will continue in both matters.
Thank you.
Thank you, Your Honor.
Court does call the case of People versus Taylor Adams.
Ashley Feltus for the people.
Assistant Public Defender Jay Bell on behalf of Mr. Adams, who approaches. Mr. Adams, can you please state your name for the record?
Taylor Adams. He's waiving.
He is waiving, Your Honor.
Sir, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes, sir.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution?
Yes, sir.
People also waive their right?
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on count 1 with 2 following. Mr. Bell.
Your Honor, we acknowledge receipt of information. We form a reading, stand mute at this time.
Defendant in every way, formal reading, standing mute. Court will enter a not guilty plea as to both counts. Pretrial will be set for
November 18th at 1:30 with Judge Conklin.
November 18, 2025, 1:30, Judge Conklin.
Thank you, Your Honor.
Bond continued.
Thank you, Your Honor.
She needs to sign.
We'll be in touch.
Court does call the case of People versus Taiwan felon.
Ashley Feltus for the people.
David I. Goldstein appearing on behalf of the defendant.
Taiwan Phelan.
Your Honor, we've had some preliminary discussions with regard to potential resolution in this matter. However, the person I need to speak to is Mr. Ganatra, and he's not available at this time. So we're going to be asking for a 1-week adjournment. If that's acceptable to the court.
Probably not, but what the heck? Probable cause conference will be adjourned September 25th, 2025. 9 a.m. Bond continues.
Your Honor, I would like to address the court on the issue of bond. I did alert
go ahead.
Ms. Phelps, and if I call her Landy, I apologize. But anyway, Your Honor, my client in this matter is charged with 3 counts. One is a maximum of 10. The other 2 are maximums of 5. They are nonviolent crimes. To my knowledge, my client has no prior criminal history and lives in Washtenaw County with his family. The other thing the court may or may not know is he does have a pending federal case which arises out of the same issues that are in this court, same weapons. And in that case, he's on an unsecured bond. So, Your Honor, I would ask the court, if the court is not going to consider a PR bond with a tether, that at least consider reducing the bond from $150,000 for a nonviolent crime with no prior criminal history. That seems excessive.
Response.
Your Honor, I do believe the bond is appropriately set. I'm trying to find the amount from my notes.
I have 150.
Cash or surety. That's what I have.
And Your Honor, this person was found to be in possession of several firearms. If I recall correctly, there was a 9mm Hellcat as well as a Glock. I can't recall what specific Glock it was. Let's see, a 40 cal Glock 23. There was significant investigation into this person's social media. They were observed being on social media with these firearms. The search warrants were executed on his residence as well as his phone, and the search warrants indicate selling the firearms. They seem to be indicating that sort of activity, which is extremely concerning to the people. Things to the nature of, you want to still get this again. That's the only word I won't say on the record on the market. Yeah, I got this 23 and G2 right now. Yeah, slide through. I want that.
Your Honor, just briefly, I don't want to get into the facts of the case because this is not the prelim, but I would only indicate with regard to counts 1 and 2 that my client, having no prior felony conviction, with regard to the firearm that's in counts 1 and 2, it's not a crime for him to possess that firearm. The issue is whether he had any knowledge that the firearm was stolen, because counts 1 and 2 both talk about stolen property. I understand that count 3 might be more of an issue, but that's what the federal case is about. But again, Your Honor.
Well, is the feds going to take this case, or?
They're not going to, there's no indication that that's one of the things Mr. Ganatra and I need to talk about. We've had no indication that they're going to take it, but they have charged him for possession of the same gun that's charged in count 3. And they saw fit to give him a PR bond.
Well, that's the feds.
Not
me.
I didn't say that, Judge. All I'm saying is that's a fact.
Well, they got a whole different way of doing stuff.
I don't disagree, Judge.
For bond reductions denied, certainly you can bring it up at the next hearing this time, but his bond will at this point will continue.
I don't see it a couple times.
Court calls the case of the people versus, is it Hatiam Al-Shalabi?
Over to behalf of the people.
Well, Judge. Court shall cease to assistant public defender on behalf of my client. Please state your name for the record, sir.
Hatiam Al-Shalabi.
Thank you, Judge. I have had a chance to speak to my client and to the, with the prosecutor. Still trying to find a resolution in this matter. We'd ask for a brief adjournment, Your Honor.
Hearing no objection, probable cause conference will be adjourned to October 9th, 2025.
Thank you very much, Judge.
Bond continues.
Thank you.
Thank you. Oh, okay. Let me do a couple. Why don't you? Take a while. Oh, do it, sure. Court does call the case of the people versus Sherry Walker.
Yes, Your Honor. Brandon Bird on behalf of Sherry Walker. Ms. Walker, can you please state your full name for the record?
Sherry Walker.
I have before me a plea form. Is that what we're doing today?
Yes, Your Honor.
Plea form indicates that the defendant will be pleading guilty to an added count 2 of retail fraud in the second degree. That's a 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed, although the sentencing judge waiver is checked on this. This is a SK 14A1 case, so it would remain with me. That's the court's full understanding of the agreement.
That's fine.
Yes, Your Honor, that's correct.
May I have her sworn?
Right. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name.
Sherry Walker.
So Walker, it's this court's understanding that you're going to plead guilty to the charge of retail fraud in the second degree. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Fine could be increased at 3 times the value of the property taken. If that's greater than $2,000, that would become your maximum fine. You understand that?
Yes, sir.
All right. Still wish to plead guilty?
Yes, sir.
To that charge, how do you plead?
Yes, sir.
How do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial? Be kind.
Yes, sir.
All right. You had signed an advice, have you signed an advice of rights form?
Yes, sir.
All right. Any question regarding any of those rights?
No, sir.
All right. You'll see a copy on the podium. Paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right?
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Somebody threatened you or coerced you?
No, sir.
You're doing this voluntarily?
Yes, sir.
Of your own free will?
Yes, sir.
And because you believe that you are indeed guilty of this offense?
Yes, sir.
On June 12, 2024, at the location of 3300 Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan, what did you do at Home Depot that makes you think that you're guilty?
I took some items that I didn't pay for.
All right. Tried to walk out of the store without paying for them?
Yes, sir.
Store was open to the public at the time?
Yes, sir.
You didn't have anybody's permission to take that property?
No, sir.
And this property you took was offered for sale?
Yes, sir.
And this is a second based upon value or prior?
That's based on value, Your Honor. It was initially a first, based on it being a subsequent, but.
Got it. Ma'am, was the items that you took, was the aggregate value of that in excess of $200?
I don't know exactly how much it was.
If I said it was $337.98, would you have a reason to dispute that?
No, sir.
All right. And so you'd stipulate or counsel agreed that that's the case?
Yes, Your Honor.
Yes, Your Honor.
All right. Ma'am, if I do accept your plea, if between the time of plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rule, you would not be entitled to any sentence. The court would not be bound by any sentence recommendation to it, and you would not be permitted to withdraw your plea. You understand that?
Yes, sir.
Is that a yes?
Yes. Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
I'm not, Your Honor.
And have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor. Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1. Probation sentencing will be
October 8th at 9 a.m.
October 8th, 2025, 9 a.m. That's before me. Bond will continue.
Thank you, Your Honor. Have a nice day.
Thank you. You do the same.
Thank you, Your Honor.
Everyone can remain seated. Court will stand in brief recess.
I'm waiting on it. Because they took a break. It's fully charged. I don't want it plugged in because it won't sit up right. As soon as I'm done, you can have it. It's all you. But I'm getting fucking anxious. I don't like to sit and put. Let's put this away.
All right. We're seeing a district court for county of washtenaw, state of Michigan, is now in session. The honorable judge case at the Simpson.
You may be seated. Court does call the case, People versus Kimani Barfield.
Assistant prosecuting attorney.
Judge Brian Bowling, Assistant Public Defender on behalf of Ms. Barfield. State your name for the record, please.
Kimani Barfield.
Thank you.
Your Honor, there is a green form in the file. I'm asking for an adjournment. Ms. Tanha and I have discussed some possible discovery that might be outstanding, so we're hoping to get to the bottom of that. So we just need a date to come back.
Thank you. October 9th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case People versus Michael. Is it Gotchentower?
Brian Bowling on behalf of Mr. Guchenauer? Gokenauer.
All right.
Your Honor, I'm also seeking an adjournment in this matter so that Ms. Feltus and I can have some additional plea discussions related to this case. So there should be a green form in the file on this one as well. Then I'd like to address bond if I could when the court's prepared.
I'll adjourn this one to September 30th, 2025 at 9. Yes, that's the bond.
Thank you, Your Honor. The current bond in this case, to my understanding, is a $5,000 10% bond. Mr. Gokenauer lives in the city of Detroit, Your Honor, by himself. However, he does have a 9-month-old daughter with his significant other that he is active in that child's life. He works as a plumber. He has jobs scheduled and in progress here in Michigan that he would like to get back to. We'd ask the court to consider granting him a personal bond in this case.
Response.
Your Honor, I do not believe my office requested a monetary component at the time of arraignment. I will note that the defendant does have a pretty significant multi-state history. So I wonder if that was a basis for setting the bond that the magistrate did. And it does look like he completed a prison term for a larceny, 1,000 to 20,000 in April. It may have been completed a parole in April of 2025, but it could have been a prison term.
It was because of the relationship to this offense to parole that caused the monetary bond.
That makes sense, Your Honor. Thank you.
Anything additional?
No further.
Motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor. Your Honor, I missed the date. I apologize.
The date is September 30th.
Thank you, Judge. Mike. Thank you, Your Honor.
Can you hold Ann needs to go bond. Court calls the case People versus Anitha Barnes.
Anitha Barnes.
Brown appearing on behalf of Ms. Barnes, Your Honor.
What are we doing?
I'm requesting adjournment.
May I say something, please?
Well, we're in court.
Can you what?
She wanted to
May I
talk to
say
me,
something,
but
please? No, I mean to the judge, to everyone. I mean, may I say something?
Go for it.
I would just like to say that I feel quite a bit of confliction here. I am still not very clear on why I'm even in court, and my attorney keeps getting changed, and it keeps getting adjourned, and no one's in clear communication.
Ma'am, I'm going to stop you. If you're worried about the attorneys getting changed and communications there, we can solve that problem by having you come down. I'll hold your file today, and then you'll be able to get a clear understanding from me directly as to what you're charged with. I don't mind going through an arraignment again, and then you can talk in detail with Mr. Brown if that's what you'd like to do.
I just would like for someone to be able to reach a little bit more out to me. I'm struggling with my transportation right now. I don't have the means for Uber, and my living situation isn't the best. I'm in a hotel, and I'm just trying to make sure I'm as clear as possible with everything that's going on is all.
Okay, I understand your concern, and I'm sure that the public defender's office does everything they can to communicate with you. It sometimes can be difficult when the client doesn't appear here and is requesting to appear via Zoom, because even the conversation on this day can't happen. So if what you'd like me to do, given the adjournment, is set it the next hearing, if you don't believe that there's communication, I'll make sure the two of you get together, because I'll demand that it be in person and you'll have to be here. If that's what you'd like me to do, I'll be more than happy to do that.
I don't mind trying to set it up beforehand, but honestly, I just started a new job and things like that. As long as it's far enough for me to actually be able to make it, I would like to show my best appearance and be a part of these things. I don't mind. I just haven't had the chance to.
What do you want me to do?
Judge, anything that you find worthy. I appreciate being able to show up Zoom. But if the problem is me being here by Zoom, I will try my hardest to make it there. I just don't want to get in trouble because I couldn't make it there.
Mr. Brown, where are you at?
Pardon me?
What do you want me to do? I don't understand what you want me to do, ma'am.
I'm requesting adjournment on her behalf, but I'll be here till 4 o'clock. She wants to come on down. I'll be happy to talk to her.
You hear that, ma'am?
Yes, I do.
Mr. Brown is very dedicated. He'll be here till 4 o'clock. All right. So if you want, if you're worried about communication and something, he will make himself available.
Okay, thank you.
Right. So you coming?
I will try my hardest. If I'll call the prosecutor's office to get your information so that I can contact you.
How about we just adjourn it and we set a meeting where you come to my office?
That would be the best.
No, she should come down here by 4. You'll be here.
Oh, okay.
I can't guarantee that I can be there by 4. I have to get my daughter from the bus stop at 4:17 exactly, and I have to figure out if anyone can give me a ride out that way first. I don't have a vehicle.
All right, I'm gonna let you guys work it out.
I'm just requesting adjournment, John. That's all.
Probable cause conference will be adjourned. I'll give you guys time to try to work this out. October 9th, 2025, 9 a.m.
You want my number again?
Yes, please. I do not have it.
222-6970.
Okay.
Okay,
thank you.
Okay.
All right. Bond will continue. Let's call the case. People versus Christopher Griggs.
Good morning, Your Honor. Raymond Cook for the people.
We're ready this man.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Griggs. Mr. Griggs, please state your name for the record.
Christopher Griggs.
Thank you.
Your Honor, today is the date and time set for the probable cause conference. We are respectfully requesting that this matter be set for preliminary examination.
All discovery is complete.
To the best of our knowledge.
People have their witnesses available the 30th.
We'll do our best, Your Honor.
Preliminary examination in person will be set September 30th, 2025 at
9 a.m.
At 9 a.m. before Judge Washington.
May we briefly address the issue of bond?
Very briefly.
Thank you. Your Honor, my client has a home in the area in which he could stay. The facts of this case is he's charged with CCW. He was driving a vehicle. That vehicle was pulled over for issues. Was not his vehicle. The owner of the vehicle was sitting in the car next to him. There were weapons found that were not in plain view. And he was subsequently charged merely for being present at the same place the weapons were eventually found. We're asking that, as we do not feel that the likelihood of conviction is very strong in this case, that his bond reflect that. He will return to all future court dates. He will abide by any strictures that the court place upon him. He's asking that he be allowed a personal recognizance bond in this case.
Your Honor, I do know the defendant does have some criminal history, as the court can see from the charging documents. One of them was possession of a short barreled rifle or shotgun. The convictions are relatively old. The most recent one I see is from 2018 for an OWI third. As defense counsel indicates, the weapon that was found in the vehicle, which the vehicle is not his, but the weapon was found in the center console and he's driving it. The other passenger also indicates it was not hers. And so there is some concern whether the strength of that case and the likelihood of conviction, that's obviously up for a potential jury to determine at that time. But I just have some concerns given the prior history. I'll leave it at that.
So, Your Honor, to respond to what he said, the passenger was the owner of the vehicle. When they stopped it, my client was very calm, very cooperative. It was the passenger who owned the vehicle who was behaving in a nervous and strange manner. Again, there's nothing that connects. Well, we don't want to get too far in the weeds on this, but essentially, I do not believe that the prosecution is going to be very successful in going forward on this case. So I'm asking that a bond reflect that.
Bond is actually, quite frankly, for a weapons charge, very low at $5,000 cash as surety. So it's at a $5,000 bond. I don't think that is an abuse of discretion. I'm not going to change it. As most for bond reduction is denied. Bond will continue. Certainly we can bring it up, but whatever. Court does call the case of the People versus Crystal Barnes.
Assistant Public Defender Chelsea Virgil is with and on behalf of Crystal Barnes, who appears via Zoom. Miss Barnes, please state your name.
Crystal Denise Barnes.
Sorry.
Your Honor, we're asking to adjourn. I've spoken to prosecution about how I'm requesting some additional discovery.
Any objections?
No objection.
Did Mr. Brown sort of grant you with his grace of not having to get me a green sheet because of age?
I thought I turned in the green sheet. I'm sorry.
No.
I will fill one out immediately. I apologize.
That's okay. Ms. Virgil, you are always very good at that. I am blaming this solely on Mr. Brown.
That's right. She asked me
because I know that it's his fault. Probable cause conference will be adjourned to October 9th, 2025, 9 a.m. Bond continued.
Thank you.
Thank you.
Thank you.
The baby.
Court calls the case People versus, is it Jakeeves Gully?
We're ready now. The Chief Public Defender Attorney Raven on behalf of Mr. Gully.
Good name, sir.
Steve is good.
First name is, say it again.
Don't worry about it. You ain't gonna get it.
You said I'm not gonna get it? I'm gonna call him Joe then. I'm not even, go ahead. What are we doing?
Your Honor, in this matter, we are respectfully requesting this matter be set for a preliminary examination.
All right. Discovery is complete to your knowledge.
To the best of our knowledge.
All right. Do other witnesses available the 30th?
We will do our best.
Preliminary examination in person, September 30th, 2025 at noon. That's before me. Oh no, I got to try to say his name again, but he won't even give it to me. That's all right. All right, bond will continue. All right, thank you. Thank you, sir. Court does call the case of the people versus Michael Boyce Smith.
Brian Boyce Smith, Judge. State your name for the record.
Michael Boyce Smith.
Your Honor, I'm asking this matter be set for a preliminary examination. I believe all discovery to be complete.
People have their witnesses available the 30th. Preliminary examination in person will be set September 30th, 2025, 9 a.m. That's before Judge Washington.
Thank you, Your Honor.
Bond continued. Thank you. Court calls the case of the people versus Andrew Harrison.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Harrison, who approaches. Can you please state your name for the record?
Andrew Marquise Harrison. Thank you.
And Your Honor, we are just asking to set for a preliminary examination today. My understanding is that all the discovery is complete.
And Your Honor, for the record, we made an offer to defendant through the counsel. This defendant has 2 misdemeanors in 15th District Court as well. So the offer would be to plead to GBH strangulation, which is count 1 in this case, as well as the domestic violence and the stalking he has against the same victim in 15th District Court. That offer has been rejected and we're ready to move to.
That is our understanding of the offer, Your Honor. He's going to give you a date right now. And my client is rejecting that at this time.
Preliminary examination in person will be set. People would have their witnesses available the 30th. The 30th.
I believe so, Your Honor.
All right. September 30th, 2025.
Okay. Yep.
At noon, that's before me.
Thank you, Your Honor.
Bond will continue. Court does call the case People versus Leticia Brock.
Good morning, Your Honor. Raymond Cook for the people.
Under Hannah Apple, on behalf of Ms. Brock, who's appearing via Zoom. Ms. Brock, will you state your name for the record?
She's there.
Ms. Brock, can you, oh, there she is. Can you state your name, please? Okay, I've seen her.
There she is.
Okay.
Thank you. Your Honor,
And we're just gonna shut your video real quick so that
can you hear
in case we have to ask you something, we'll hear you. Go ahead.
Your Honor, we're asking for an adjournment. We did receive the discovery, but however, we're asking for some additional time to review the video with my client.
All right. Without objection, probable cause conference, October 9th, 2025, 9 a.m. Bond continue.
Thank you.
Court does call the case People versus Marcus Jackson.
Good morning again, Your Honor. Assistant Public Defender Davie Leva on behalf of Mr. Jackson, who approaches from my right.
Douglas for the people.
Your name?
Marcus Jackson.
Thank you.
And Your Honor, we are requesting adjournment today. I've provided a green sheet to the clerk, and I would be asking to address bond.
Probable cause conference will be adjourned September 30th, 2025, 9 a.m. as the bond.
Thank you, Your Honor. Mr. Jackson is currently being held in a $500,000 cash or surety bond. We would ask the court to consider a lower bond or perhaps even a personal bond with a home confinement tether. He does have a full-time job at Primoris Renewable Energy, and he's very concerned that job will be lost if he remains in custody. He does have a place to stay in Dundee at an address that I can provide to the court. And again, we have no objection to a home confinement tether with release for work. I do also want to note that he has ties to the community, including the support of his fiance, who is present here today.
Response.
Your Honor, the people would object to a reduction in the bond. We believe that Mr. Jackson poses a danger and a flight risk. The reason that Mr. Jackson's bond is so high is based on some of these allegations. It's that police tried to effect a traffic stop after seeing him run a red light. And that not only did he not stop, but that he fled at some point, drove in a circle around the police car, and continued to drive at a high rate of speed, doing U-turns, going into a parking lot, running multiple red lights, that he was driving in and out of oncoming traffic lanes, trying to evade the police, that he ended up intentionally driving headfirst into the vehicle of a police officer, disabling it with the crash, and continuing to drive, and while trying to get away, ended up hitting 2 other police cars. When the car finally stopped, when police had pinned him in, he said he was still fleeing on foot. He did have a passenger in the car. The passenger stayed there, said that did not know why Mr. Jackson had fled, and he was just a passenger. He spoke to police and cooperated with them. However, Mr. Jackson fled on foot. Police tried tasing him multiple times, and eventually had to just tackle him. He continued to try to get away from police once they had physical hold of him, Your Honor, and the police indicated that he smelled of alcohol. Now, Your Honor, he was recently arrested for OWI on August 17, 2025. Our office does have that warrant request, however, it's not yet been charged. And so, Your Honor, we do believe that there's a danger here in that him being arrested on August 17th for OWI, and then him being arrested this time with the driving that we saw and smelling of alcohol, and allegations of drinking and driving in this case. I'd also note that he does appear to come from Georgia. His license is from Georgia, and so we do think that there is a flight risk here based on that, and that is why we believe that the bond is appropriate as such.
I just want to make sure I heard that correctly. He went headlong into a police vehicle?
Yes, Your Honor. Front crash, disabling the vehicle, and that car is unable to operate.
Anything else to say?
No, Your Honor.
Before I deny your request?
No, Your Honor, but I appreciate the
Motion for bond
consideration.
reduction is denied. Thank you. Bond will continue.
Should be apparent in the Bureau of Prisons. They handed down 507, the one that's unmuted.
Got it. Court does call the case of People versus a Johnny Wright.
Anjanae Wright.
Anjanae, I'm sorry. It's been a morning. We thought that was you that had dialed in. All right.
Good morning, Your Honor. Tina Saxon on behalf of Anjanae Wright.
All right. What are we doing on this?
Your Honor, I was just appointed yesterday, and I have not even had a chance to speak to Ms. Wright. I'm asking for an adjournment.
You're in the Bureau of Prisons, correct, Ms. Wright?
Yes, I am.
In Minnesota, Your Honor, so I'm also trying to get on the list so that we can have a conversation or video visit.
What I'll do is I'll adjourn the probable cause to October 23rd, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Okay.
Have a great day.
Thank you. Thank you, Ms. Wright.
Thank you.
Court does call the case of
Sorry.
Yeah, good. Court does call the case of People versus Marvis Jones.
Assistant Public Defender Jay Bellinger on behalf of Mr. Jones, Your Honor. Mr. Jones, can you please state your name for the record?
Marvis Keaton Jones.
And Your Honor, we are just asking to set these for preliminary examination today. It doesn't look like we're getting an offer on these.
Doesn't look like.
It doesn't look like there's an offer at this time on these cases, Your Honor.
And discovery is complete here.
To the best of our knowledge, Your Honor.
People have their witnesses available the 30th.
Do our best, Your Honor.
Preliminary examination in these matters will be set for September 30th, 2025, 9 a.m. before Judge Washington.
And Your Honor, if I may briefly address bond.
May.
Your Honor, my client is currently on parole. He advises that he can live in parole housing in Toledo, where he would be supervised by parole. During my understanding is that these cases are 5 to 6 years old. They're not violent offenses that are being alleged here. In 2020, when he didn't I understand that the warrants have been out on these for quite some time, obviously. In 2020, at the time that the warrants were issued, my client lost his daughter, unfortunately, due to gun violence. That took precedent in his life at the time over these. My client understands the serious nature of these cases and is willing to obviously appear for them. I understand he's in custody right now, but he does assure the court that he would be willing to appear. Like I said, he has supervision in Toledo where he can stay in parole housing. So we would just be asking for his release at this time.
Response.
Your Honor, defendant was on bench warrant status for multiple years and never turned himself in. That like concern the risk, especially if it sounds like he's going to be residing out of state. I have further concerns that he's not going to return back. Going to just let these go into bench warrant status again. I'd ask the motion to be denied.
And Your Honor, if I may briefly respond to that, my client was in prison at the time that this happened as well. So there was not much of an option for him to address these. He did attempt to do that so that he could see about getting time served on these at the time, but he was unable to do so.
This time there are 3 cases. That preliminary examination before Judge Washington. So on the 30th, given everything, the court is going to decline to reduce his bond at this time. Motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor.
Yeah, you did.
Case of the people versus Maurice Burgess.
People.
Assistant Public Defender Jay Bellinger, on behalf of, but not with Mr. Burgeons, Your Honor, we have just spoken to Mr. Burgeons' wife about 20 minutes ago. My understanding is that he's on his way to court. I understand that there's also.
Where is he?
Your Honor, I did.
Got some real problems.
Your Honor,
and I want him here now.
Your Honor, I do understand that as well. If the court would be willing to pass this case to the next.
Absolutely.
Thank you.
I want him here in the next 5 minutes.
I will do my best, Your Honor.
I'm taking him or you. See how good he does. What, everybody's trying to hold him up now, so take him. Melissa Konwinski.
Assistant Public Defender Chelsea Vergils with and on behalf of Melissa Konwinski. Ms. Konwinski, please state your name.
My name is Melissa Marie Konwinski.
Can you sign here to waive the preliminary exam?
What are we doing?
Your Honor, my client is currently signing a preliminary exam waiver form, so we would ask to waive that and get up to circuit court. I would also ask to address bond.
Ma'am, you're waiving your right to a preliminary examination?
Yes, Your Honor.
Do you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes, Your Honor.
You understand you'll not have that hearing? You'll proceed to circuit court for further resolution. People also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on a single count.
We acknowledge receipt of the information, waive its formal reading, and stand mute.
Defendant able to formal reading, standing mute. Court will enter not guilty plea. Pretrial will be set for
September 30th at 1:30 for Judge Cummings.
September 30th, 2025, 1:30 before Judge Cummings. As to bond.
Your Honor, we are asking for release on a personal bond with a scram tether, or if the court is not willing to consider that today, we're asking to set a cash bond because I believe her bond is currently denied. And I believe her current actions while in custody and her plan for being out of custody demonstrate her commitment to her sobriety. So in custody now, she is going to church, she's going to AA, she's enrolled in Dawn Farm. She has been also taking mental health classes. Her plan for when she gets out of custody is continue with the AA, of course, with her fellow Bear River alumni and to do intensive outpatient with Trinity Health. We do actually have printed out her email confirmation that she has an appointment on September 22nd. Very much like to be at that appointment and get going with her intensive outpatient treatment. Again, coupled with the AA classes, her continued mental health treatment with CMH, I think that She has compiled a great plan to hopefully have success with her sobriety.
Response.
I think the court recalls,
I do.
thank you, Ms. Tomlinski, and the concern of the people, it's multiple, but on an OWI with BAC of a 0.28 with a crash that she fled the scene from and 2 priors from 2021, and then drinking while on bond, I have significant concerns, which are not alleviated by the then lying about it being mouthwash and about, sort of making excuses for herself. Glad to hear things have changed. Glad to hear things are getting better in jail. But if the court is going to consider any release, I would request that it be with a scram tether.
At this point, given everything, I understand the plan. I understand where she's headed. However, she was basically almost a 0.3. She gets a PR bond with a release to tell her not to drink, and she just can't do it. Even though that's there, I think there's going to have to be a little bit more structure from my standpoint before I would release her. So at this point, your motion for bond reduction is denied, and her bond will continue as denied.
Okay.
Court does call the case of People versus Nicholas Chalmers.
Assistant Public Defender Chelsea Vergils on behalf of Nicholas Chalmers, who appears via Zoom. Please state your name.
Nicholas Chalmers.
Thank you, sir.
We are asking to adjourn for additional discovery. Does the court happen to have a green sheet?
I do.
Awesome.
Without objection, probable cause conference will be adjourned October 9th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, sir. Court does call the case of the People versus Dion Richmond.
Andrew Baptist. Ready, Your Honor. Assistant Public Defender Jay Bellinger on behalf of Mr. Richmond. Mr. Richmond, can you please state your name for the record?
Dion Richmond. Thank you.
And Your Honor, we are asking to set this matter for preliminary examination at this time.
Discovery complete.
To the best of my knowledge, Your Honor. I also understand that there is a tentative offer. I have not been able to go over that with Mr. Richmond. However, I'm still working out the details of that. If we are able to resolve prior to preliminary examination, we certainly will.
People have their witnesses available the 30th.
I believe so, Your Honor.
Preliminary examination in person, September 30th. 2025, 9 a.m. That's at noon. At noon, that is before me.
Thank you, Your Honor.
On continued. Court does call the case People versus LaShawn Charles.
Assistant Public Defender Jay Bellinger on behalf of Ms. Charles, who appears via Zoom. Ms. Charles, can you please state your name for the record?
LaShawn Charles.
Say your name again, please.
LaShawn Charles.
Thank you.
And Your Honor, I am just asking for an adjournment on this matter. I am still trying to work out some sort of resolution for Ms. Charles at this time, so I'm just asking for 2 to 3 weeks.
Probable cause conference will be adjourned October 9th, 2025, 9 a.m. Bond continues.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you, ma'am. Court does call the case of the People versus Javier Ruda. Javier Ruda, I don't you this.
Bring me to the People.
Ron Brown appearing on behalf of Mr. Ruda. Sir, can you introduce yourself?
Javier Rueda Noguera.
We'd ask the court to set this down for preliminary examination. See if the witness can show up.
What is it? Discovery is complete.
To my knowledge, Your Honor.
People have their witnesses available the 30th.
We'll do our best.
Preliminary examination will be set September 30th, 2025, 9 a.m. before Judge Washington. Bond continued. Court calls case People versus Tristan Clay Ratcliffe.
Morning, Your Honor. People.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Clay Radcliffe. You state your name for the record. Tristan Clay Radcliffe. And Your Honor, I am asking for an adjournment on this matter. We just need to confirm that restitution was paid in full before discussing an offer on this. My client advises that he paid restitution in full in January, so we did give that information over the prosecution. So just a couple weeks so we can see
But
about.
not to the court. So it's not something the court could track. He paid it.
Correct. He paid that way back in January, Your Honor.
To the court?
Not to the court, Your Honor.
Not to the court.
Correct.
And that's accurate, Your Honor. I just received that documentation from opposing counsel this morning, so I just need to confirm with the victim to make sure that that was paid.
Probable cause conference will be adjourned September 30th, 2025, 9 a.m. Bond continued.
Your Honor, I did supply the court with a stipulated order for amended bond for my client.
I know.
Oh, okay. I'm sorry. Is that something that the court is willing to sign? Maybe you said something and I didn't hear you. I
Is
apologize.
your other client here yet?
I'm working on it, Your Honor. Diligently.
So he wants me to do something here, and I asked him to do a little thing. Again, and he won't do that. So I probably shouldn't sign his order.
Oh, well, that has nothing to do with this guy.
This guy being your client?
Correct.
Okay, you're right. I've already signed.
Thank you very much, Your Honor. Thank you. Thank you, Your Honor.
Did you see what he has nothing to do with this guy? Court calls the case People versus Jeremiah Sawyer.
And production people.
Great Judge. Court will please to Assistant Public Defender on behalf of Mr. Sawyer, who is approaching the podium. Mr. Sawyer, when you get here, please state your name for the record.
Jeremiah Sawyer. Thank you, sir.
Thank you, Judge. I have reached out to the people and I've spoken to Mr. Sawyer. We are asking for a brief adjournment to continue negotiations.
Probable cause conference will be set September 30th, 2025.
Thank you very much, Judge.
And bond continue.
We'll be in touch.
Thank you.
September 30th.
Court does call the case People versus Wanalan Cleaver.
Morning, Your Honor. People.
Good morning again, Your Honor. Assistant Public Defender Deputy Lebo for Mr. Jake Quellen Cleaver.
Your name?
Jaqueline Cleaver.
Correct. Got it.
And Your Honor, we are requesting an adjournment of about 3 weeks, and I have provided a green sheet.
It'll take you 3 weeks to review discovery.
We also would like to begin some negotiations, Your Honor.
Probable cause conference October 9th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Court calls case People versus D'Angelo Simmons. Gotta squeeze in.
Right, again, Judge. Court shall please to Assistant Public Defender on behalf of Mr. Simmons. Mr. Simmons, please state your name for the record.
D'Angelo Simmons.
Thank you, Judge. My understanding at the last court date, the competency was, he was found competent.
Yes.
We are still negotiating with the people to try to find a potential resolution on this matter. We'd ask for an adjournment.
This is the only thing he's held on, or?
As far as I know, Your Honor.
Probable cause conference will be adjourned September 30th, 2025, 9 a.m. Bond continue.
Thank you, Judge. We'll be in touch.
Court does call the case People versus Deshaun Clifton.
This is Public Defender Hannah Apple appearing on behalf of Mr. Clifton, who's approaching now. Your Honor, Mr. Clifton has executed a preliminary exam waiver.
Say your name.
Yes.
Deshaun Clifton.
Thank you. You signed this examination waiver?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on counts 1 and 2 with 3 following.
Your Honor, we acknowledge receipt of the information. We'll stand mute, wait for more reading.
Defendant having waived formal reading, standing mute as to all 3 counts. Court will enter the a not guilty plea. Pretrial will be set for
November 10th at 1:30.
November 10th, 2025, 1:30 before Judge Hammoud.
Thank you, Your Honor.
Your Honor, if I may also place on the record, that waiver was made. There is an offer that he would plead to count 1, count 2 and 3 would be dismissed. There was discussion of adding a count 4 for reckless driving that will not be added based on the waiver.
And that's correct, Your Honor.
All right, very good. Bond will continue.
Thank you.
Thank you. Court calls the case of the People versus Bosie Smith.
Good morning, Your Honor. Marie Canha, Assistant Prosecuting Attorney on behalf of the people.
And good morning, Your Honor. Sydney Rushing, P78830, appearing on behalf of Mr. Smith, who's approaching the podium. Mr. Smith, can you state your name for the record?
Boise Smith. Thank you.
Your Honor, we have not received discovery yet in this matter. I did request it. I received a response asking for the signed order of my appointment. I did say that I had the one that was submitted to the court along with Ms. Wheatling's response saying that it was signed, and then they left me on red, Judge. So they didn't want to send me the discovery prior to.
Wow. That was really accusatory. Is that what they
I
did?
received a response. So that's what I think happened. They left me on red.
Okay, so just knowing how this is going to work, I'm sure we have a response from Miss Tana. Go.
Ms. Rushing, if you want to send it directly to me, I'll make sure it's taken care of. I'm not aware of what happened or who left you on red. It certainly wasn't me personally. I would never do such a thing. And Ms. Rushing, there is something important I do need to discuss with you regarding this case that I forgot to put on the record. So if you could email me or get in touch with me somehow as soon as possible, I'd appreciate it. Your Honor, there's also an additional matter. This defendant making calls to the victim's number, the number that is listed in the police report from other hands since he was arraigned. At the time that we looked into this, there were 7 calls made. The concerning part of this, in addition to the calls being made against his bond conditions and the privilege of being in the situation he is, the calls are concerning because he is having people instruct her essentially as to what she needs to do and not do, and so on. I haven't listened to them personally. I will do so. I'll make sure that Ms. Rushing gets those calls so that we can discuss it further. However, at this point, based on what we do have, I'd ask for his phone privileges to be removed.
Your Honor, if I may.
Yes.
I would ask that you consider putting this over for 1 week and before you're granting that request. I think I heard the people say that they haven't heard them personally yet either. So that means neither her or I have heard them to confirm what was said or what wasn't said. So I'd ask if you would consider just holding that order or motion in abeyance for 1 week for me to review them. That is my only request. Thank you, Judge.
And potentially have your client make additional calls to the victim, now knowing that they're on to it. I'm not going to do that. Defendant's phone privileges are hereby ordered revoked pending a hearing. And if you want a hearing on that, I'll be more than happy to set that up for you. Probable cause conference in this case, if you wanted to during the week, I'll give you a week. I'll set it for September 25th, 2025, 9 a.m.
Thank you so much, Your Honor. I greatly appreciate it.
Thank you, Bond.
Have a great day to you and your wonderful staff.
You do the same. And I called your case, didn't leave you on red, right?
You didn't, Judge. I really appreciate that. You always make sure I'm taken care of. I appreciate it.
Thank you.
Have a great day, Judge.
Sure. Court does call the case of the People versus Danina Combs.
Brown, go ahead.
Gosh, calls for the people.
Brown appearing on behalf of Ms. Combs, Your Honor. I was going to request an adjournment.
I'm sure you were.
I got your green.
In light of the violation?
Got your green paper?
Like Bellinger. I know. You.
Should I file it?
I'm here.
You can file it. I'm not. Is she here?
Yes.
What's your name?
Danina Combs.
She's got a violation, so she's going to need to appear personally.
You hear the judge? You got to come down. He wants to see you.
Your Honor, I got into a bad car accident and my back spine is broken in 2 spots. I can't.
Are
even
you in the
walk.
hospital?
I just got out.
Okay, so here's what I'm gonna
Day
do.
before
I'm gonna
yesterday.
set this for 3
But-
o'clock, giving you an opportunity, or for 2 o'clock. Giving you an opportunity to send to Mr. Brown, who's apparently gonna be here till 4. To
Yeah, I
send to
got out.
Mr.
I got
Brown
out.
detailed information regarding that. Otherwise, I will expect you here.
Okay. I have the paperwork.
Okay, get that to Mr. Brown so he can let me know.
Okay.
Thank you.
Thank you.
Court does call the case People versus Matthew Verbeil. Mr. Bellinger, do you have your client yet, or do I need to send my people?
Your Honor, he is on a bus.
No.
Okay, we'll talk.
And Your Honor, good afternoon, sister. Good morning, Simpson Defender W. Leba with and on behalf of Mr. Verville. Mr. Verville, can you state your name?
Matthew Verbeil. Thank you.
And Your Honor, we are requesting an adjournment today, and I have provided a green sheet to the prosecutor. I'm sorry, to the clerk.
The is that you guys doing investigation that's gonna take a minute, or what?
Your Honor, so this is a matter involving a child abuse allegation. We've requested the CPS report. So it's going to depend on how quickly they will provide that to us.
Probable cause conference will be adjourned September 30th, 2025. 9 p.m. bond continued.
Thank you, Your Honor.
Yes.
I have some additional.
Oh, okay, go ahead.
There is going to be a child advocacy center interview in this case. Hasn't been scheduled yet.
Got it.
You maybe have an additional week just to ensure that.
That's fine. You have any objection to that?
I have no objection to that, Your
Okay,
Honor.
I was setting it that way so that because he was in custody, but my next date would be October 9th, 2025, 9 a.m. Bond continued.
Thank you.
Thank you. Court calls the case People versus Rachel Corser.
Andrew Banish for the people.
Assistant Public Defender Chelsea Vergils with and on behalf of Rachel Corser, who appears via Zoom. Ms. Corser, please unmute and state your name.
Rachel Ian Corser.
Thank you.
Your Honor, we're asking to adjourn. There has very recently been an offer that I'm asking for time to discuss with Ms. Corser.
Probable cause conference will be adjourned October 9th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you.
You don't want to address bond? No, I'm kidding. Go. I'm sorry. Court calls the case People versus Sean Beater.
Andrew Banish for the people.
Hello. Your name?
Sean Vitter.
All right. What are we doing?
Who's? Cannon's case.
Whose? She was here. Yeah, one case. One case. She was here. When I call it, she's not.
Truth to that. Stephanie Cannon on behalf of Mr. Beater, who is standing to my right. Mr. Beater, could you please state your name for the record?
Sean Vitter.
We made his finding.
We have not made it as of yet, Your Honor. I did provide the court with paperwork as it relates to a finding of competency.
The test already is passed.
Yeah, you did. You passed with mine?
Yes.
And so I did provide the prosecutor and this honorable court with that information, Your Honor.
Yes, and I have reviewed that. Is there any additional information either from the people or defendant?
Your Honor, we will stipulate to those findings. It is my understanding that paperwork for criminal responsibility has already been submitted. It's my belief and understanding is that.
I don't know about that.
On September 4th, Your Honor, signed both the order for competency evaluation. It's now been found competent. People also stipulated to that. I have no further information on that. I saw in my file that you also signed an order for evaluation relative to criminal responsibility. I'm not sure if they're proceeding with that or not. But
I don't know if they are, but I wouldn't deal with it here. That would be dealt with in circuit court, so I'm not even addressing that. Having no other evidence as it regards competency, court upon review of that report would find that the defendant is competent to stay in trial, would find specifically that he can understand the nature and objects of the proceedings against him and can rationally assist his defense. Therefore, the defendant is deemed competent. I do order, I have signed that. You would like this set for probably. No.
Yes, Your Honor. I need the opportunity to speak with my client. I did attempt to do so twice this week, but there were some things going on at the time. It appears that he's a little bit better now, so hopefully I'll be able to speak with him prior to the next hearing.
Would you like the 30th or October 9th?
Your Honor, the 30th is fine.
All right. Probable cause conference will be set October 30th, 2025, 9 a.m. Bond continued. Thank you.
Thanks.
Can you sign this for me?
I don't really want to give my information out there.
Okay, that's perfectly fine. You don't have to. Thank you.
Court does call the case People versus Dustin Duncan.
Brian Bowling on behalf of Mr. Duncan, who it's my understanding he's present on Zoom, Judge.
Yes, he is.
Yes.
And
can you state your name for the record, please, sir?
Dustin Wade Duncan.
he needs to be here.
Right, Judge. Mr. Duncan requested Zoom, which was approved, then revoked based on the community corrections report that was issued in this court issuing a bench.
So how soon can he be here?
So, Your Honor, he's at the University of Michigan Hospital for a medical procedure right now. It's up to the discretion of the court. I mean, I think he probably be there.
3 o'clock. He needs to get here.
Okay.
Otherwise, there's going to be a warrant.
Mr. Duncan, the judge is ordering you to appear here by 3 o'clock this afternoon. Okay.
Okay. Thank you, Your Honor.
Thank you.
Thanks, Judge.
Court calls the case People versus Jeffrey Williams. Let me get counsel. Oh.
This Mr. Williams?
It is.
It is.
Ron Pring on behalf of Jeffrey Williams. We sent over a form for him to be referred to the 15th.
What?
We sent a form over for the 15th mental health court.
I don't have any. When did you send that this morning?
Monday or Tuesday.
I'll sign off on it. I don't have a problem doing that, but I don't have it right with me right now. We'd
Yes,
have to
Your Honor.
turn it out anyway.
Yes, Your Honor.
State your name, sir.
Jeffrey Leon Williams.
Thank you.
So I'm requesting adjournment.
All right. If you get that, if it's over to me today and everybody signed off, I don't have a problem signing it, and sending it over.
Thank you, Your Honor.
I'll set then I'll adjourn this out to the October 9th day.
Thank you.
2025, 9 a.m. Bond will continue. All right. Thank you, Mr. Williams. Court does call the case of the People versus Christopher Coffey.
Good morning, Your Honor. Raymond Cook with the People.
Good morning, Your Honor. Again, J. Grant Miller, P58658, on behalf of Mr. Coffey, who now stands to my right.
Your name, sir?
Christopher Coffey, sir.
All right.
Your Honor, I've had an opportunity to discuss this matter with Mr. Coffey this morning. I have the discovery from the People, so we'd like to set this for an exam.
All right.
No objection to setting for exam.
All right. I just want to get the record clear so that the defendant was sending emails directly to me. I provided those to counsel. as I indicated to council at the time that those were coming through to my email, I was not aware that defendant was on the court's docket. I read it. It in no way impacts this court's ability to handle that. And as I've indicated, council, I handed those over to you. Some of the statements I would only indicate relate to a defendant that I think I've had 3 preliminary exams on, so.
And Your Honor, for the record, I don't believe it's any conflict. I have a copy of those, and I appreciate the court sending those.
And for the record, Your Honor, defense acknowledges receiving the copies of the email, and I believe the court, just for clarification on the record, the 3 other preliminary examinations are not Mr. Coffey.
That is correct. That is correct.
Thank you, Your Honor.
All right. Would the people have their witnesses available on the 30th?
At least one of them we know, and we can try with the other 2.
Defense will be ready, Your Honor.
Preliminary, yes. Preliminary examination in person will be set September 30th, 2025 at noon before me.
Thank you, Your Honor.
Bond continued.
Thank you, Your Honor.
Yeah.
Yeah, I can create my.
Yeah, well.
Okay.
Court does call the case People versus Thomas Lee Ellis.
National Office for People.
Judge. Portia Feaster, on behalf of Mr. Ellis, is approaching the podium. Mr. Ellis, please state your name for the record.
Thomas Ellis.
Thank you, Judge. My understanding is Mr. Ellis has negotiating with the people in this matter. Sounds like they're moving towards a resolution, but have not yet reached one. So he's asking for some additional time for me to speak to Ms. Feltus and see about a resolution.
Probable cause conference will be adjourned October 9th, 2025, 9 a.m. Or as your invite indicates, bond will continue.
Your Honor, can you confirm the defendant's testing conditions for me, please?
Why? You want to know, is he on the silver link?
Yes.
You have a silver link.
Yeah, I've been on it for almost a year now.
Yeah.
Thank you, Your Honor.
All right. Thank you very much, Judge.
Thank you.
October 9th.
The court does call the case People versus Deidre Woods.
Your Honor, with the people.
Ready again, Judge. Portia Feaster, Assistant Public Defender on behalf of Ms. Woods. Ms. Woods, please state your name for the record.
Beatrice Woods.
Thank you.
Thank you, Judge. I've spoken to Ms. Woods several times over the last few days. She has indicated she'd like me to request this matter be set for a preliminary examination.
You have all of the discovery.
Oh, no, you want to waive it? Oh, I'm sorry, Judge.
She doesn't want it now?
She does not now. She wants to waive her preliminary examination. It sounds like, Your Honor.
You want to waive it?
Yes, sir.
All right.
Okay.
You understand that a preliminary examination is a proceeding where the people have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand now that you will not have that hearing, that you'll proceed to circuit court for further resolution.
Yes, sir.
All right, that's what you want to do.
Yes, sir.
All right. People also waive their right?
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on counts 1 and 2 with 3 following.
Thank you, Judge. We will waive formal reading and stand mute.
Defendant having waived formal reading, standing mute to all 3 counts. Court will enter a not guilty plea. Pretrial will be set for
October 1st at 1:30.
October 1st, 2025, 1:30 before Judge Conlon.
Thank you, Your Honor.
Thank you very much, Judge.
Bond will continue.
Thank you very much, Judge.
Thank you. That's probably over to Weber. Court does call the case People versus Mike Games.
Andrew Bash.
Brown, pretty nothing.
Got a low there.
Yeah, I'm not doing too good today. Well, I'm doing well. I mean,
Yeah, she's not here.
she's not here.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000. Cash surety, that warrant will issue immediately. Court calls the case of People versus Jennifer Burnside.
Ask Phelps for the people.
Assistant Public Defender Chelsea Vergils with and on behalf of Jennifer Burnside. Please state your name.
Jennifer Marie Burnside.
Thank you.
Your Honor, we are asking to adjourn because Ms. Burnside intends to hire a private attorney who I've spoken with. He's out of town, but will certainly be at her next probable cause conference.
You have a medical marijuana card?
I do, Your Honor.
Your Honor, I do have, so her medical marijuana card expired June 9th. However, she applied for a new one and was approved. I have the email confirmation.
Shocking. Anyway, go ahead.
With just the email confirmation showing that her card should be in the mail very soon.
I don't have a dispute. I didn't have a note directly that she had one, so that's the only reason I inquired. So you have counsel stepping in. When are they available soon or?
From what I understand, he's just out of town this week.
Oh, gotcha. Okay. So what I will do then in this case is I'll adjourn it out, give time to catch up on everything to October 9th, 2025 at 9 a.m. All right, ma'am? Bond will continue. You're welcome. Courthouse case, People versus Lester Braggs. That's it.
Stephanie Cannon on behalf of Mr. Braggs, Your Honor.
Oh, you're here?
I am here, Your Honor.
Yeah, but no client.
Your Honor, my client.
You're doing well.
I know it's a great, great day.
Yeah.
14A1. My client is en route, Your Honor. He had taken so many days off, they wouldn't let him have today off. So he left work and he is driving in. If the court, it's for a plea, a really good plea. He is trying to get here, Your Honor. He's trying. I would just ask if we could move it to the next block, and hopefully my client will be here soon. Please.
How come every time I'm calling your cases, we have a problem?
Your Honor, I'm beginning to think it's me.
Oh, you're beginning to think that?
I'm beginning to think it might be me.
It's you.
Your Honor, he is en route. He couldn't take, it was either lose his job or be in court. So he's en route.
So what, he waited for a shift to end and then left? Is that?
Yes, Your Honor.
When's he? Okay.
So he works in Detroit. When I called him about 20 minutes ago.
He's got a car.
Yes.
She's not going to be on a bus.
No, he's not going to be on a bus. He's driving in for his plea. And it'll be great.
Don't ever say I haven't done anything nice for you.
I won't, Your Honor. I
Shoot you
wouldn't
the next block.
never say
If
that.
he doesn't show up, you're going to St. Place Bellinger's. Because I'm about to call his case and I think I know what the answer is.
We'll be there together.
We'll be there. Thank you so much, Your Honor.
You're welcome, Miss Cannon. Court now has called the case of the People versus Maurice Burgess.
Ask Phelps for the people.
Assistant Public Defender Jay Bellinger, on behalf of, but not with Mr. Burgess. Your Honor.
Mr. Allen. No, don't.
Your Honor, we did get a hold of his wife again. She advised that he got on the smart bus from Inkster sometime this morning. I had my intern take a look to see what
from Inkster this morning.
From Inkster this morning. Apparently that bus route takes 2.5 hours. I would ask I would ask the court.
Hold on. No. He was here.
Yeah, he was at community corrections this morning.
Yeah. Oh, that's not true.
Wait, what? What do you know that I don't?
What?
What do you know that I don't?
Oh, I know a whole lot of things, which is why I want your client.
Okay. Well, yeah, I'm aware.
So he got on the smart bus.
That's what we're informed. We were informed
this morning.
We were informed by his wife that that's what he did, Your Honor. Because my understanding was that he had to take public transportation from
Oh, no, don't worry about it. I don't have to.
I don't know.
I don't need an answer.
Okay.
So he's on the smart bus. Alleged. And he's coming here.
What I asked him to do this morning, Your Honor, was to check in and get tested with community corrections
Right.
prior to coming to court.
Okay, so he's gonna be coming down on the smart bus. Right?
Far as I know, as far as I've been advised, Your Honor.
So how long does this smart bus take?
My intern looked that up and she said it was a 2.5 hour route because it had to stop at the airport first.
Oh, this is the airport bus? Oh, no. All right, fine. You know what? Is that your intern?
There's an,
Is that your intern?
That is my intern, Your Honor.
That's the one that said it's gonna take 2.5 hours? Okay, no.
I don't
Here's
want
what
to
we'll
speak
do.
for her, Your Honor.
We'll call this in the 2 o'clock block.
Okay.
If he got on this morning, then he should be here by then.
I completely agree and understand, Your Honor.
I will await his arrival.
Thank you for your grace.
Sometimes that's all I have. There's a white man.
First fracture.
All right. I think that's it.
John,
Yeah.
I got the hospital records from Miss Danita Combs, if you want to see it.
can we approach it?
Yes, come on up. I was gonna take a break.
Well, you want to take a break first?
No, because then I'll just be coming back to you. Come on. I think that's it that I have for that block. Our next block up's up in about an hour, so we actually get some time to. Why are you clapping this loud? I get lunch. All right, court's gonna. What is this?
It's right here.
I think it's Ron's.
Oh, it's Ron. Ron,
Yes, sir.
you left paperwork of your client's violation up.
Well, I didn't mean to. You got one.
Thank you. All right, court will stand in recess.
All right.
Recording.
Be seated.
She barely has a
Commission is now back in. Honorable Judge J. Cedric Simpson presides.
You may be seated. Court does call the case of People versus Lester Braggs.
Jennifer Douglas with people.
And
This is also. Whether or not he can. And it's.
Stephanie Cannon on behalf of Mr. Bragg, right there, Your Honor.
yeah, I want to see my face now. Come in, but okay.
Stephanie Cannon on behalf of Mr. Bragg. Mr. Bragg, could you please state your name for the record? Put your hands out of your pocket.
Lester Bragg.
All right.
And Your Honor, we do have a plea in this matter. However, they won't let him pay restitution.
Your Honor, restitution is a prerequisite for the plea. I don't know, the court may remember that there was an order signed to allow the payment of the restitution in order to obtain the reduction.
Okay, so what happened?
So
He tries to go pay.
they said and said no. That's what they said. That's what they said. And said just have him come to court. So I went to the window with him. We went to 2 different windows. Somebody by the name of Autumn was involved. And then at the end of it, we were told just to come here.
Clarify with the clerk's office, because their impression was that he was seen already this morning. There should be a note from today, but his permission to pay his restitution as bond was given weeks ago. They did not require him back.
I don't know. He's
As we figured out this morning, Miss Cannon, it
It's
is
me.
you.
It's me.
Yeah.
It's me. He will gladly give the money.
Okay, all right. I just have this one philosophy in life.
Tell me, okay.
If somebody's giving you money, take it. You can always issue a refund if necessary.
The clerk does not agree. So, Your Honor, I don't know if we should adjourn it again. I don't know what.
Why you want to, no, we're not.
Okay.
I don't see any paperwork, but let's get this taken care of, because you'd adjourn it, they'd come back, that clerk wouldn't take money at that point.
Okay.
So this is a 14-2 case. There is an order allowing the payment of restitution.
Yes, as a condition of bond. That is correct, Your Honor.
Mr. Bragg, go down to the clerk's office, pay the restitution. All right?
Yes,
Tell
sir.
them the judge said, I can pay the restitution.
Yeah, tell
Let's see
it.
what they said.
Judge said.
Because if I got to go down there, that's not going to be pretty.
Okay,
Thank you.
thank you.
Smiley? Yes, please send a message, because if I got to go down there, I don't want to go down there. Okay, well, that was fun. Court does call the case, People versus Reginald Hunter.
Andrew Bennett.
Good afternoon, Your Honor. Sam Bernstein, covering for attorney David Burgess with and on behalf of Mr. Hunter. Could you please state your name for the court?
Reginald Hunter.
And you have no objection to Mr. Bernstein?
No.
All right, good.
Mr. Burgess is requesting an adjournment, Your Honor.
Probable cause conference will be adjourned. Did he indicate to you how long he needed, or?
Let's not do him any favors, Judge, just like the October 9th date is fine.
October 9th, 2025. I'm not talking to you anymore. 1:30 or 9 a.m. I'm sorry. Bond continued. Thank you. Court calls case of People versus Kendra Weathers.
Andrew Bennett.
Good afternoon, Your Honor. Sam Bernstein with and on behalf of Ms. Weathers. State your name.
Kendra Weathers.
Thank you.
And I've had some back and forth about a resolution in this case, Your Honor. And I think one more adjournment, we should have that resolution in place.
Probable cause conference will be adjourned to September 30th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls the case, People versus Amber Cormos.
Good afternoon, Your Honor. Raymond Cook with the people.
Good afternoon, Your Honor. J. Grant Miller, P58658, on behalf of Ms. Cormos, who approaches on my right. Please state your name.
Amber Cormos.
All right.
Your Honor, today's date time set for PCC. I did receive a lot of video discovery from the people, including what was over 2.5 hours of a backseat of a cop car where they had my client and another person sitting. We're asking for an adjournment to put it over 2 or 3 weeks. I think I have about 20 hours of video I have to watch, and I just want to make sure that it's all complete. And of course, Ms. Cormos is going to have to watch that video as well.
Probable cause conference October 9th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you. Bond continued. Court calls the case, People versus Monica Thompson.
Good afternoon, Your Honor. Raymond Cook with the people.
Good afternoon, Rob G. Cool on behalf of Ms. Thompson. Monica, would you state your name?
Monica Thompson.
Judge, scoot over here. I was just appointed on this case yesterday, but I did receive discovery. I went over it with Ms. Thompson. She did make admissions to the point where she understands the right to have an exam. She signed the waiver. I explained that to her. So we're going to go up to circuit court and try and work something out.
You're waiving your right to a preliminary exam?
That's correct.
All right. You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes.
You understand that you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
You'll also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendant bound over to circuit court on the
Judge, as far as the information, we waive its reading. My client would stay on mute and we would ask
defendant having waived.
pretrial date.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
November 10th at 1:30 with Judge Hamud.
November 10th, 2025, 1:30, Judge Hamud.
November 10th. Judge Hamud. Thank you, Judge.
Thank you. Bond continued. Thank you, ma'am. Court calls the case of the People versus Emily Bates. He's going to need to sign up.
Brenda Judge, Mr. Assistant Public Defender, on behalf of and hopefully with Miss Emily Bates, who normally appears on Zoom. It sounds like she may not be on Zoom today, Your Honor. I don't know why she is not present. I would be requesting an adjournment. She normally does appear, and I know she is in treatment out of state, if I recall correctly. I believe she's in treatment out of state last I had contact with her, Your Honor.
Bench warrant will issue for defendant's failure to prepare bond 10,000 cash surety. That warrant will issue immediately.
Thank you, Judge.
Thank you. It can just, yeah, it might be, but just take it. Court calls the case, People versus Aaron Griggs.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Griggs, who appears via Zoom. Mr. Griggs, can you please state your name for the record?
Aaron David Griggs.
Okay, you got him.
Yes.
Aaron
Thank
David
you.
Griggs.
Thank you, Mr. Griggs. Your Honor, I am seeking an adjournment in this matter. I have not been able to have a lengthy conversation with my client with regard to his case, so I would ask for a 3-week adjournment so that we may do that, and I'd ask that Mr. Griggs give me a call before the date of his PCC so that we may discuss that.
October 9th, 2025, 9 a.m. bond continued.
Thank you, Your Honor.
Court calls case People versus Joseph Haffley.
Why am I always last?
Good afternoon, Your Honor. Marie Tanner, Assistant Prosecutor.
What?
We're ready in this matter on the long round. Deputy Chief Public Defender appearing on behalf of Mr. Haffley. participating by Zoom in the black. Could you state your name for the record, sir?
My name is Joseph Havely.
Your Honor, today's the date and time set for a probable cause conference. Mr. Hafley is currently in treatment. So we're going to ask, Mr. Hafley, how far along are you in that treatment right now?
I believe I'm about 10 days in, 9 or 10 days.
Okay. We'd like to ask for a probable cause conference some 3 weeks out. Will you have completed the treatment in 3 weeks, Mr. Hafley?
I believe right now my tentative discharge date is October 6th.
No objection for the record, Your Honor, to the adjournment. Mr. Brown, if you want to contact me regarding misdemeanor offer.
Absolutely. Thank you.
Probable cause, October 9th, 2025, 9 a.m. bond continued.
Thank you very much.
Thank you. Thank you, sir. Court calls case People versus Robert Harris.
Douglas for the people?
Ron Brown appearing on behalf of Robert Harris.
Oh, here he is. Oh, I knew that. I saw him back there.
Your Honor, I'm requesting a brief adjournment so that I can talk to him.
Your name, sir? Robert. Take your hands up. Probable cause conference will be adjourned September 30th, 2025, 9 a.m. Bond continued. Come on. Court calls case People versus Michelle Harrison.
Andrew Banners with the people.
Stephanie Cannon on behalf of Ms. Harrison. And I don't have a green sheet, Your Honor, but I will. We're going to request an adjournment of this matter. My client just provided me with a lot of information. I am going to prepare mitigation information to provide to the prosecutor in this case.
Probable cause conference, October 9th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Yeah. Thank you. Court calls the case People versus DeMarco Henderson.
Douglas for the people. Stephanie Cannon on behalf of Mr. Henderson. Stephanie Cannon on behalf of Mr. Henderson, Your Honor. Mr. Henderson and I have not had the opportunity to connect on this matter. And as such, I'll be asking for a brief adjournment. And also I found the green sheet for Ms. Harrison as well. So we're asking for a brief adjournment, Your Honor.
That objection, September 30th, 2025. Bond continued.
Thank you, Your Honor. It's all yours.
Court calls the case of the People versus Randy Hockenberry.
Your Honor, Mariana, Assistant Prosecuting Attorney.
Assistant Public Defender Chelsea Virgil with and on behalf of Randy Hockenberry. Please state your name.
Randy Hockenberry.
Your Honor, we are asking for an adjournment today so that we can continue our plea discussion and so I can review some discovery with Mr. Hockenberry.
No objection to the adjournment.
Probable cause conference, October 9th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls case People versus Dexter Hubbard.
Oh, that's mine. Ron Brown Pring on behalf of Mr. Hubbard. Mr. Hubbard, can you introduce yourself?
Dexter Hubbard.
Your Honor, I'm requesting an adjournment. I want to review the discovery with him. Please.
Cause conference, October 9th, 2025, 9 a.m.
Thank you.
Bond continue. Court calls case People versus Andra Hunter.
Andrew Banners for the people.
Good afternoon, Your Honor. Assistant Public Defender Davy Lieba on behalf of Mr. Andra Hunter, who stands to my right. Can you state your name?
Andra Hunter.
And Your Honor, we're going to be requesting an adjournment today. We still need to receive the body camera in this matter that has not yet been provided, to my understanding.
Probable cause conference, October 9th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Court calls case People versus Kare Jackson.
Simple Thunder, Hannah Apple on behalf of Ms. Jackson. Ms. Jackson. Oh, there we go. Okay.
Ms. Jackson, we see your name for the record.
Kare Jackson.
Thank you.
Waiver to sign. Okay. Your Honor, she is executing a preliminary examination waiver.
Ma'am, you're waiving your right to preliminary examination?
Yes, ma'am. Yes, sir.
You understand that that's a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed.
Yes, Your Honor.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, been bound over to circuit court on a single count.
Thank you, Your Honor. We acknowledge receipt of the information. We'll stand mute at this time.
Pending every waiver for reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
November 10th at 12:30, judgment.
November 10th, 2025, 1:30, Judge Hammoud.
Okay. Thank you, Judge.
Thank
Bond
you.
continue.
Okay, and you'll be up.
Court calls the case of the People versus Cassandra Johnson.
For the people?
Your Honor, Brian Mullane on behalf of Ms. Johnson, my office identified a conflict in this matter. So it was my understanding substitute counsel had been appointed. But it doesn't appear as if anybody else is standing here with me, whether it be Ms. Johnson or substitute counsel. So, I mean, I could walk down the hallway and see what's going on down there, but
you can do what you want to do. I'm going to issue a bench warrant.
Okay.
Bench warrant.
Fair enough.
Relation for defendant's failure to bond will be set in $10,000 cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Court calls case People versus Dominic Johnson.
Good afternoon. Rita, Assistant Prosecuting Attorney on behalf of the people.
Stephanie Cannon on behalf of Mr. Johnson. Mr. Johnson, when you are at the lectern, please state your name for the record.
Dominic Johnson.
And Your Honor, we are going to adjourn this for a little bit of additional investigation on the part of my office.
Any objection?
No objection, Your Honor.
October 9th, 2025, 9 a.m. Bond continue.
Thank you.
So October. Do you need anything to remind you?
Court calls case People versus Kelsey Jordan.
Good afternoon, Your Honor. Raymond Cook for the people.
And good afternoon, Assistant Public Defender Davey Lee before Ms. Jordan is approaching from my right. Jordan, could you please tell the court your name?
Kelsey Jordan.
And Your Honor, I have provided a green sheet to the court. We're asking for an adjournment in order to continue negotiations as well as provide a substance assessment to the prosecutor.
Probable cause conference, September 30th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Call the case, People versus Melissa Justice.
Andrew Banners for the people.
Ready, Judge. Four-show feature Assistant Public Defender on behalf of Miss Melissa Justice, who is approaching the podium. Please state your name for the record.
Melissa Justice. Thank you.
Thank you, Judge. I've had a chance to speak to Miss Justice. I did email the
Can
prosecutor.
you take your hands out of your pockets?
Oh, I'm sorry.
My understanding is that there's a substantial amount of video discovery, and I need to have a chance to review that with Miss Justice. If we could adjourn this for a few weeks.
Probable cause conference, October 9th, 2025, 9 a.m. Bond continued.
Thank you, Judge. October 9th. Yep.
Court calls case People versus Christopher Kosnick.
Good afternoon, Your Honor. Ray Sandhouse, Assistant Prosecutor. Your name, please.
Ron Brown appearing on behalf of Mr. Kosnick. I think he's appearing on Zoom. Mr. Kosnick.
Is that him? You want to know why he's last?
Yes, sir.
Introduce yourself to the judge.
Christopher Kosnick, Your Honor.
And by the way, sir, we all heard you. You're not last, but if you want me to pass it, I can put you last.
I apologize, Your Honor. I was trying to adapt to the technology. My apologies.
Yeah, I know. All right. But make sure to hit mute before you try to say something smart. Mr. Brown.
Your Honor, we're requesting an adjournment, if at all possible.
So hold on a minute. I don't want no adjournment. I want this over with.
Well, hold on. You and I talked on the phone the other day. Now you got to let me work.
Yeah, okay.
Since Mr. Brown has to work, Your Honor, no.
I'll call you.
October 9th, 2025. 9 a.m. Bond continued.
I'll call you.
Thank you, Your Honor.
Waiting till. Because I understand the technology, so I don't want to say anything.
I believe Bates is now here.
Miss-
She's frozen.
Miss Bates?
Yeah. I'm gonna hold on. I think she.
I'm sorry, can you hear me now?
We can hear you. Your screen is from. See if you shut your screen.
I'm sorry. I apologize. I can't hear you now. I'm sorry. Can you repeat, Your Honor?
Court recalls the case of. What did I do? Oh, yeah. Recall the case of People versus Emily Bates.
And for those to the people?
Ready again, Judge. Four-show feature Assistant Public Defender on behalf of Miss Emily Bates.
Hello.
Hello, Miss Bates. State your name.
Hello, Your Honor. My name is Emily Bates.
You are so lucky.
I am, Judge.
No, you are lucky that Ann likes you.
Look, I am lucky. I appreciate it. Thank you very much.
I appreciate your court's patience. Thank you so much for your representation. I appreciate your patience, and it's been a pleasure watching your courtroom. So thank you to both of you, gentlemen. I hope you have a blessed day. Thank you.
Oh, don't leave yet.
I won't. No, sir, I won't.
You sounded. Thank you for that. It sounded like she was signing off. All right.
Not at all. Not at all. I just want to. I've enjoyed this experience. It's a pleasure to meet your company, and thank you, Eva.
Thank you, Miss Bates. We appreciate it. I believe she's still in treatment, Judge. I'm still waiting for some records from her psychiatrist. If we could adjourn.
Okay.
Yes, Judge.
All right. So what I'm going to do, I'll give you a little bit longer.
Thank you, Judge.
I'll adjourn this without objection to October 23rd, 2025 at 9 a.m.
Thank you, Thank you, gentlemen. In your honor, I just wanted to let you both know that my therapist did send over paperwork today to both your courtroom and the attorney, and I can gather more documentation as well as proof that I'm enrolling in school for a music degree in here at Salt Lake City, and I will send that over to make sure that I resend everything by that court date. But thank you again. Have a beautiful day. I look forward to seeing you again, sir. Thank you, sir.
And you, ma'am. Take care.
Thank you, Ms. Bates.
Thank you, sir. Enjoy the day. Stay safe.
You too.
Thank you.
Court calls case, People versus Dennis Link.
Andrew Van.
Stephanie Canada, Link.
Yeah, my God. Oh.
I'm a mess. Don't look at it. State your name for the record.
Dennis Link. Thank you.
And Your Honor, at this time, we're simply asking that this case be set for a preliminary exam.
Discovery complete.
To my knowledge, yes.
People have their witnesses available on the 30th.
I believe so, Your Honor.
Preliminary examination in person will be set September 30th, 2025 at noon before me.
Thank you so much, Your Honor.
Thank you. Bond continue. Court calls case People versus Gerald Manning.
Good afternoon. Good afternoon, Honor. We can
Good afternoon, Your Honor. I too must work. My client, Mr. Manning, is present. Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Manning. Mr. Manning, state your name.
Gerald Manning. What are we attempting to do on this?
Your Honor, we would like to set this matter for a preliminary examination where we can work together.
I have a violation report.
Oh, I believe we received an email this morning.
Did you see that, Mr.?
I did not.
A violation? I think we got it this morning and it was sent.
Parties this morning.
It was sent, okay, this morning. Did you have a chance to see that, Mr.?
Yeah, I have it pulled up.
Why don't I pass it?
Yes, sir.
And you can have my copy.
Thank you.
Temporarily. Yeah, Mr. Ruff. And I'll pass the matter so he knows what we're dealing with.
All right, thank you.
Court does recall the case People versus Lester Braggs.
People.
And Stephanie Cannon on behalf of Mr. Braggs. And he's going to be here, Your Honor.
Where is he?
I'm told he went down to pay the money.
He paid the money.
Oh, great. Oh, I hope he didn't leave. Your Honor, could I have a moment? So the good news is he paid the money.
He did. And he was here. I saw him.
Here.
So Miss Kent, relax. All right. If he paid the money today, let's hypothetically say the clerks would have taken it to start out with, what would have happened? Canon, ye of little faith, there's your client.
He was always going to be here, Your Honor. Thank you, Your Honor.
So what are we doing?
Your Honor, with that, I do believe we will have a plea in this matter.
You had the paperwork filled
I
out?
do have the paperwork, Your Honor.
You do?
I do indeed.
Your Honor, there is a small amount still owing, but at this point, that will be, and
okay.
The balance can be paid.
Just so that you know, Okay, he posted $511 of 570.
Yes, that is correct.
So the small amount you're talking about is the difference between that?
Yes, Your Honor, but, based on how much it is, we'll go ahead.
Okay, very good.
Yes, that is.
The plea form that I have indicates that the defendant will be pleading guilty to the charge of larceny, $200 or more, but less than $1,000, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. And defendant agrees to pay $569.97. It says prior to the plea, he got most of that in. But
Yes, Your Honor. If we could amend it to say prior to sentencing.
that's fine. I'll do that. All right. That's the court's full understanding of it.
Yes, Your Honor, thank you, Your Honor.
That's my complete and full understanding.
May I have the defendant's sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name.
Lester Braggs.
Mr. Wright, first of all, let me apologize to you on behalf of the court. They should have taken your money the first time that you walked up there.
Okay.
Shouldn't have had to be going back and forth. So accept my apologies, please, sir. All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of larceny, 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than 2,000, that would become your maximum fine. You understand that, sir?
Yes, sir.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 district court.
Okay.
You understand that?
Yes, sir.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Yes, sir.
Guilty.
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
All right. You signed an advice of rights form. Is that correct?
Yes, sir.
Any question regarding those rights?
No, sir.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights in that form.
So as you already read.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily?
Yes, sir.
Of your own free will?
Yes, sir.
And because you believe that you are indeed guilty of this offense?
Yes, sir.
November 13, 2019, location in 9841 MacArthur Boulevard, Superior Township, Washtenaw County, State of Michigan. What'd you do that makes you think that you're guilty of this?
I didn't hear you, sir.
What'd you do at that time, at that date, on that date, and at that location that makes you think that you're guilty?
I left with some belongings that didn't belong to me.
Okay, you were at somebody else's house?
Yes, sir.
And then you just took these particular items, like it was an Amazon Fire tablet, an iPhone, and a Nintendo Switch?
Yes, sir.
Okay, and that property did not belong to you?
No, sir.
All right. And so you also didn't have the owner's permission or the owner of that property's permission to take it, did you?
No, sir.
All right. If I accept your plea, I do have to advise you that if you commit misconduct as defined under the Michigan court rules between the time of the plea and the time of your sentencing, the court would not be obligated or bound by any recommendation in this case, because there's a recommendation of HIDA.
Yes, sir.
You understand that?
Yes, sir.
Okay. And also you would not be entitled to withdraw your plea.
Yes, sir.
That's right. All right. Counsel, are there any other pleas, promises, pleas, or other inducements which have led to this plea?
No, Your Honor.
None that I am aware of, Your Honor.
All right. And have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
In the court has, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered. Sentencing in this case,
October 14th at 10 a.m.
October 14th, 2025, 10 a.m. before Judge Barr. Bond will continue.
Thank you, Your Honor.
Thank
Thank you. Court calls the case of the People versus Christopher Melton.
Good afternoon, Your Honor. Raymond Cook for the people.
Your Honor, that is me, Mr. Melton.
How does she do this? How does she manage?
You let her get away with it.
No, I really don't. I just,
The bus right now.
I thought that was him sitting right there. I didn't know where you were going, Cannon. I said, I do not, that's not the guy. I'm misremembering. And
I am the guy, Honor.
yeah, you're good.
Okay, I'm just making sense. You know, she had a hard day. It's
I
okay.
did. Mr. Melton knows this.
Sir, would you please state your name?
Christopher J. Melton of Van Buren Township.
Thank you.
Thank you, Your Honor. At this time, we're going to ask for a brief adjournment. We did receive discovery this morning, and my client and I have not had the opportunity to go over it. And so we're just asking for a brief adjournment.
Just don't want to put it too far out before you forget what he looks like. Just saying.
I'll give her a photo if I could.
Okay, yeah, you may have to. October 9th, 2025, 9 a.m. And I'll get a green sheet bond. We'll continue. Thank you.
Thank you so much, Your Honor.
Thank you, Your Honor.
Ms. Cannon, you understand he was actually being very nice to you because he realizes you had a hard day.
I just looked in the wrong direction. I was like, look at the.
No, you looked right at it. You passed it. Okay, don't try to make excuses. All right. Calls the case, People versus Robert Miller.
Good afternoon, I'm Rachel.
Ready, Judge Torsho Feaster, Assistant Public Defender, on behalf of Mr. Miller, who is approaching the podium. Please state your name for the record, sir.
Robert Miller. Thank you.
Thank you, Judge. I have spoken to my client and I communicated with Ms. Tanha. Mr. Miller has indicated he wants me to set this matter for preliminary examination. There is an offer Ms. Tanha communicated to me yesterday. In the meanwhile, I will continue to work with Ms. Tanha to see if we can call off the witnesses and get it resolved. But at this point, Mr. Miller is asking for his examination. That's my understanding.
And for the record, that offer was to plead to the domestic violence misdemeanor, along with an added misdemeanor count of attempted interference with electronic communications with restitution on all accounts. Dismissal of the remaining counts. So we'll consider that rejected at this point.
All right. And people would have their witnesses available the 30th?
If we could go maybe additional week now.
Sure. You have any objections?
No, Judge.
Preliminary examination in person will be set October 7th, 2025, 9 a.m. before Judge Perry.
October 7th.
Bond will continue.
They're always in person. All right. It's all right. Good.
So go home.
Good. You all set. October 7th.
Y'all go email it to me.
Call my office. All right. Thank you, Judge.
You know he's got a phone that he's looking at right now. You gotta just put it in there.
Make sure he has.
Huh?
Yeah.
No, I'll just issue the bench warrant now. We'll save time. Court calls the case, People versus Ryan Miller.
Brian Bowling on behalf of Mr. Miller, just state your name for the record, please.
Ryan Miller.
Your Honor, Mr. Miller's prepared to waive his right to a preliminary examination.
Is that correct, sir?
Yes, sir.
And you understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes, I do.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on both counts.
waive formal reading, or acknowledge receipt of the information, waive its formal reading and stand mute.
Defendant having waived formal reading, standing mute, court will enter not guilty plea. Pretrial in this matter will be set for
November 6th at 1:30 with Judge Slade.
November 6th, 2025, 1:30, Judge Slay.
Thank you, Your Honor.
Thank you, Bond.
Judge.
Court does call the cases of the people versus Demarion Makowski Smith.
Good afternoon, Your Honor. People.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Makowski Smith, also standing in for Mr. Burdell with Mr. Makowski Smith's permission, Your Honor.
Is that a quick statement, sir? No objection to standing in on both your cases?
Yes, Your Honor.
No objection?
Oh, wait. No.
Do you agree that I can stand in for Mr. Burdell?
Oh, yes.
Okay, all right. I think the way we were asking it,
That's fair.
understood each other. All right.
And Your Honor, we are planning on waiving today. I did get permission from the client to sign that form as well as Mr. Burdell's, so both are on there.
All right. Is that correct? You're waiving preliminary examination in both of these matters, sir?
Yes, Your Honor.
All right, and you understand that that's a proceeding where the people would have to show by probable cause that the offenses here were alleged, that these offenses as alleged were committed and that you committed them. You understand that?
Yes, Your Honor.
You understand you'll not have that hearing on either case. You'll proceed to circuit court for further resolution.
Yes, Your Honor.
All right. People also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on the single count in each case.
Your Honor, we acknowledge receipt of information, waive formal reading, stand mute at this time.
Defendant having waived formal reading, standing mute, court will enter not guilty plea. Pre-trial will be set for
November 18th at 1:30 with Judge Cummings.
November 18, 2025, 1:30 before Judge Cummings.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Here you go. Where you need to be and what time and date.
Okay.
Okay?
Hold on a second.
Nope, we'll be in touch.
Bond book. Oh, I didn't.
Recall before I
No.
do this.
Oh. Court recalls the case People versus Gerald Manning. I need my copy.
What's around?
Oh, you got it.
Your Honor, with respect to the violation, if you look at page 2 of that document, it indicates
The
that
second page or page 2?
there's a page 2. Yeah, so go to
Page 2 of the report?
Yes.
Page 2 of the doc.
on the report.
Okay. Yes, go ahead.
All right. So in the second paragraph there, I believe it says that he was at a court proceeding, he was given permission to be able to contact his soon-to-be ex-wife so they could have any discussions concerning the children through an app. Does the court see that?
Yeah.
Okay. And so that's what he did. He used the app according to what he was told in court. He was also advised by his divorce attorney that he could use that app to go ahead and have contact strictly so that he could talk about care of the children. So it was a court order that allowed this. He sent that, and he has a.
You're saying it was a court order coming off of the divorce case,
right? That allowed him to be able to do it.
And Your Honor, that is a general understanding. There is a little correction I would make to that is that he was told that he could make that contact with that app once there had been a change, and the change hadn't actually happened. Did it? However, having said that, I'm going to leave it to the court's discretion. You know, there's nothing I see where I would ask for a violation here.
Okay. There was supposed to be a change before he used the app. How soon thereafter did the change that was supposed to happen?
Did the change
I believe it was the same day. So my divorce was Friday, the 12th, and I sent it. I think it was Thursday, the day before.
So it happened the next day, though. So he sent it Thursday.
Okay. So
and then the change happened Friday. I'm
you
sorry.
were a day early.
Yes, Your Honor.
Really? So for that, I ought to really lock you up. Sir, I'm not gonna do that.
I appreciate that, Your Honor.
I mean, as I was reading it, I was thinking to myself, there's probably some good explanation for this, so.
Yes,
I get
sir.
it. So he was a day early.
And there's no other like text or anything. It's automated through that, so I don't get to speak on anything.
No, I got it. I understand how it works, so, okay. I'm not gonna find a violation.
I appreciate that, Your Honor.
He's trying to take care of his kids and maneuver that whole thing, so.
Yes, Your Honor.
So we're asking for a preliminary examination.
No, discovery is complete.
To the best of our knowledge.
People had their witnesses available the 30th.
And again, Your Honor, if we could go an additional week out.
Why is she asking that?
I think I'm being very polite, Your Honor.
I know, but why? I didn't ask whether or not you're very nice. I'm just like, why? She's
Your Honor,
always.
I believe the September 30th, the docket is quite enormous, and we all have some concerns.
On the 30th?
Getting through it.
I'm on that docket. Oh, we're gonna get through it. Whether or not anybody gets dinner, that's their business.
We don't have any objection. My client's out of custody, so we don't have.
Wow, and Mr. Brown being that, geez. I don't know what's in here. All right.